just that. Learn how you can prevent and manage chronic conditions like heart disease and diabetes at AAHP's diabetes education classes and heart health classes. Consider AAHP your partner in health. Learn more about AAHP and our programs and services on our website, www.aahpmontgomerycounty.org.
I love taking care of my mom. It wasn't easy at first. She learned how to better communicate her needs.
And you learned how to not ignore yours.
I discovered how to make healthier meals.
And I discovered how much I enjoyed them.
Becoming a caregiver is a learning experience for everyone.
Good evening, everybody. Welcome to the second night of the Montgomery County Delegation local bill hearings. Just a reminder, we are live on TV and the internet. Our local committee chairs will hold the hearings for the bills in their local committees, so I'll be turning it over to the individual chairs in a moment. Just a reminder, when your name is called up, please come up, and when you're on the mic, you have to turn the mic on, and when you're done talking, please turn it off. It makes the audio for the people watching at home, the hundreds of thousands watching at home, it makes it so they can hear a little bit better. The light will go off. The yellow light will go off when you have 30 seconds left. The red light and the beeping will go off when your time is expired. So please respect the time limits because we have a lot of great folks signed up to testify on all this important legislation. People representing groups have 3 minutes. Individuals have 2 minutes. And just a reminder on all these bills, this is just the start of the work on these bills. There'll be work sessions once our legislative session begins in Annapolis in January. So this is just the beginning of the conversation. So with that, Chair Zucker, anything you'd like to say to get us started?
Well, thank you very much, Mr. Chairman. I had a 20-minute opening presentation, but I figured just the interest of time, thank you for including the Montgomery County Senate, and look forward to a good hearing today.
Great. So with that, I'm going to turn it over to the Chair of our Economic Development Committee, Chair Kelly.
Thank you, Mr. Chair. The first bill tonight is MC 920, Montgomery County Alcoholic Beverages, Hours of Consumption. It's requested by the Chair, and I'd like to call up Amy Salmon and Kathy Durbin. Ooh, oh, they're there. They're coming slow. They were sitting in the back tonight.
Good evening, Madam Chair, members of the delegation. Amy Sman on behalf of Montgomery County. This is a bill that we requested to do a little bit of cleanup work in the Alcohol Beverages Code, a task that seems to never end. The first change, repeals the hours prohibiting consumption that are listed in a specific section of the code because those hours are now obsolete. The second change repeals and it's another section in its entirety because those hours are also now obsolete. The third part of the bill repeals something referencing hours on New Year's Day. And if you recall, over the last several sessions, we have attempted to change all of the specified federal holidays to just say if it's designated a public holiday by the federal government, the hours can be a little bit later. So that is why that one is going to be repealed. The county supports the bill. And Kathy Durbin is here to answer any specific questions.
Any questions from the members? All right, that looks like an easy one. Thank you so much. That concludes the hearing on MC 920. And now we will have MC 1120, Montgomery County Alcoholic Beverages Consumption Only Marketplace License. Delegate Chi is going to present this bill, and I'll also call up Jay Brinson.
Good evening, colleagues. Delegate Chi, I'm here on behalf of my district mate, Vice Chair of Economic Matters Committee, Delegate Kathleen Dumais, who cannot be here tonight. I'm here to introduce MC 1120, which is an enabling legislation that would allow a shopping center owner to obtain a license, a consumption-only marketplace license, which would allow consumption of alcohol in a designated contiguous area in the shopping center if that shopping center meets certain criteria, which includes at least 10 acres of size. And that means in Montgomery County we have about 3 places that meet that criteria, a few places that meet that criteria. With this license, consumers who purchase the beer, wine, or liquor from a restaurant within the shopping center can consume the alcohol in a designated outdoor area contiguous to the place where alcohol is purchased and during certain hours and days. The license would not allow consumption in any parking areas or near parking garages, other stores, for example, or re-entry into restaurants, or any places not connected to the place of purchase. There will also be security on site. The precedents of this bill are the Fairfax Corner, and the Amazon HQ2 in National Landing, as well as Phoenix, Arizona. This bill is supported by the county executive, and earlier today, the county council also added some amendments to the bill that would include a better definition of the shopping center owner, which could be developer, and would require that that a developer, the owner, or the owner have a security plan at the time of license application, and also that the beverage be clearly marked with the seller's brand identity, not the manufacturer's brand identity. So we know it's in a marked cup in the public area. Jay here and Kathy Durbin from the county's Department of Beverage Services are here to answer questions. Thank you.
Questions from the committee? I just have one. Who would this apply to? You said about 3 in the county.
I'm aware of 3, but I'll let Jay speak to that.
It's probably, I don't know the exact number off the top of my head, but it's a 10-acre site under contiguous ownership. So within our portfolio, I work with Federal Realty, so within our portfolio, Pike and Rose, Rockville Town Square, Bethesda Row, for example, would fall under this. Other properties outside of our ownership, Rio would be one. Park Potomac would be another one that would also fall under this potentially.
Thank you very much. Senator Kramer.
Thank you, Madam Chair. Can you explain to me how the serving process works? In other words, if I'm understanding correctly, let's say there's a restaurant that has on-sale consumption of some kind, And now, as part of that, there's going to be an outdoor seating area that's contiguous, correct? Directly to?
Correct.
Okay. And the service will be provided by that business that has the, I guess, you know, the base license? I'm not sure what you would call it, because I'm guessing these complement one another. Is that it? In other words, if it's Ben's Restaurant and I want outdoor seating, Ben, who has the restaurant, won't be applying for the license. You, as the property owner or the property manager, will? Is that?
As I understand it, it's a joint application because there has to be a base license holder associated that has the appropriate license to be able to serve. So what we're looking for is the restaurant or establishment that is adjacent to or contiguous with the outdoor public gathering space. It's already in existence. We're looking to give them the ability to allow alcohol to move off of their already designated premises outside of their defined cafe seating zone into the adjacent public space, which would be better defined within the license application.
And it will be then their employees who have whatever the mandated training is for serving alcohol, doing
Correct.
it. Okay.
Correct, but the security plan would be done jointly with the property owner.
Okay, and if there's a violation of any kind, where does that land? On the base alcohol? I'm looking at Kathy in the distance, and I
don't know the
see her
answer.
head, I think, nodding up and down on that one.
I'm sorry, so accountability would be for the developer who would be applying for the consumption-only license, and then any license establishment contiguous that it has signed on to be part of it. So all of them would have accountability by the Board of License Commissioners.
Okay, thank you very much, thank you.
Before I call on Delegate Kaiser, I just want to make sure the members in the audience know it's a little dark up here on the table people are testifying at. We're working on the lighting. I think there was a power outage over the weekend, so hopefully we'll get it fixed. But if not, I apologize to Delegate Kaiser.
Thank you, Madam Chair. My question is to Ms. Durbin. For so many years, we've been working together, this committee, this delegation, on undoing a lot of these alcohol laws that have all these hoops and all these extra special things. Why are we putting into this bill this 10-acre limitation? Is that so we can have 4 more bills over the next decade, reducing it? I'm being
job security for me. No. So actually, we do have the ability for the smaller areas to have catering extensions or business modifications now. So this is really meant for the larger areas that want to have a common space, special specified area within their larger area where people can come and meet in a common place. So we already have the ability for the smaller areas to do that. So I think we've got it covered if we do this. We'll see.
Any further questions from the committee? Wonderful, thank you so much. That ends the hearing on MC 1120. Now we're going to have MC 2720, Montgomery County Alcoholic Beverage Licenses, catering extension, requested by Delegate Charkoudian. And I think Tricia Swanson is going to come up with her.
Good. She's going to give most of the answers. Mr. Chair, Madam Chair, thank you. For the record, Delegate Lord Charkoudian. And this bill is one of those correction bills, Delegate Kaiser, that you mentioned. The catering extension legislation was created before a Class D liquor license existed. So Class D liquor license came subsequent to the catering extension, and the catering extension never sort of went back and filled in that Class D ought to have a catering ability as well. Class D are some of the smaller businesses in the community. Denizens is the one in my district, some of you may be familiar with. But the idea was just that the specifics of the catering extension were never intended to exclude Class D license holders. They just didn't exist at the time. And so now it expands to all the various alcohol license holders that we have. So I'll let you say more about that.
Tricia Swanson, Vice President Government Relations for the Montgomery County Chamber of Commerce. I'm also here on behalf of one of our members this evening, Julie Verratti with Denison's, is traveling for work and isn't able to be here, so I'm here. The delegate did a fantastic job explaining the bill. Julie had reached out to us a couple months ago and expressed a desire to cater events. Like the other license holders can do, there are 3 other classifications that have this catering extension, and Denison's is not one of them, so fairly simple. She just wants the ability to cater.
Questions from the committee? Okay, excellent. Thank you. And there's no opposition to this bill, so that concludes the hearing on MC 2720. Moving right along, we are done with alcohol bills. MC 2320, Montgomery County Property Tax Credit for Senior Citizen Volunteers. I believe that's being presented by Senator Kramer and Delegates Crutchfield, Cullison, and Stewart. I think Senator Kramer is going to handle it.
I'll do my best to represent Team D19.
We know you can do it.
Good afternoon, chairs, members of the delegation. Ben Kramer here on behalf of the entire District 19 team to introduce MC 2320. And as much as we would love to take credit for this legislation, it is the brainchild of Councilmember Albornoz, who I was expecting to be here this evening, although I glanced around the room and I didn't see him, so he may not be here. But this is enabling legislation that would allow the Montgomery County Council to adopt a property tax credit to be offered to our senior residents who volunteer at Montgomery County Public Schools or a nonprofit organization. This actually is an issue that has come up and been raised by a lot of folks to me through the past several years because within my district and my involvement in a number of areas, including the Commission on Aging, the Maryland Commission on Aging, this is an issue that comes up frequently about how about maybe energizing our seniors who are out there and available and able to help participate and volunteer, but also give them a little incentive to come out and do these things. And it also, for many of our seniors, it costs them money and they're on fixed budgets to get out, to drive to wherever they're going to be volunteering, and then to pay for their lunch out during the day, so they have gas money, they have food expenses, and the idea is that this is just a little bit of an offset to help them do what they are trying to do, and that is participate and volunteer. So it's enabling legislation. The details will be worked out by the county council should we see fit to grant them this authority in the enabling legislation.
Thank you. If it's okay, Delegate Resnick, we have one more individual signed up to support. I'll call her up and let, is Cindy Karst here? Come on up, and I see Councilmember Albornoz is also on the list, but I don't see him here. So we'll just hear from all the proponents at once, and then I know we have some questions. Go ahead.
So, press the mic before speaking. I'm good? Okay, thank you. I'm a little nervous. I've never done this before, so bear with me. But I was told to just tell my story, so here it is. I've lived in Montgomery County for 12 years. My husband has lived here on and off most of his life, and so have his parents. We live in a neighborhood. We bake each other stuff for the holidays and exchange gifts, small ones. We volunteer locally. We take each other to the hospital for same-day surgery, and we check in on each other's kids and dogs if you're on vacation or you run into an emergency. And when somebody dies, like recently in our neighborhood right next door, we're there with baked goods and to take the kids back and forth to school and to do what's necessary. So my story is, I don't want to leave Montgomery County. I'd like to age in place. And this little bit of help would make it easier to pay for being here on a fixed income. It's a great place. It's a great place to be and grow old too, if you can afford it.
Good point.
Thank you very much for your testimony. Are you concluded? Yes.
Yes.
Delegate Resnick.
Thank you, Madam Chair. Senator, I love what you're trying to do with this bill. I do have a more specific question, though, and I know that you want to leave the specifics to the county council, but we can't always do that. One of my
Don't trust them, eh?
It's not that I don't trust them. I like to verify, though. You have no definition of a nonprofit organization in this bill, and so I'm concerned as to how expansive that might be. Under federal code, an exempt organization could be a social club, the local poker group if they're registered as a C7. If you volunteer for that, you really want to give them a tax break for that. A C4, Super PAC is licensed under a C4. Do we want people who are raising money for Governor Hogan's dark money super PAC to be getting a tax credit for that? So I think we need a little more definition in terms of what kind of nonprofits you're referring to. What do you think?
I would certainly have no problem with that, and I don't know what we have in the way of prior examples within current state code. I'm confident we can, find definitions that exist now without having to work too hard at inventing the wheel here. So I would certainly welcome that, and I'm confident that the council would embrace your idea there of perhaps making sure that it is not overly broad.
Thank you so much.
Thank you.
Any more questions? Wonderful. Thank you so much for your testimony. I'm going to call up, we have two people signed up in opposition. Kathy, I'm sorry if I pronounced this wrong, Gugulis. Kathy Gugulis and Hesse Harris.
Well, good evening. I'm Hesse Harris. This bill seems well-intentioned but not well thought out. First, there's the matter of vetting. There must be extensive background checks. We all know that there are people we do not want near any pupils or students. Regrettably, that the opposite has happened too many times, not only here but elsewhere. The same need for extensive background checks holds for the nonprofit organizations. Lest there be character issues or prior conduct that could be embarrassing for the county. Now, who's going to pay for the background checks? In addition, will there be a specified list of approved agencies? The county should be concerned that the nonprofit organization involved not be controversial. Okay, there's also an indication, there's no indication of what duties the volunteer will be performing. That's certainly a concern with regard to the public schools. However, it's also a concern with regard to the nonprofit organization and volunteers. Third, there's a matter of health. School personnel are subject to some form of physical examination prior to being employed. There's a measles epidemic in this country. There should be screening for that and any other communicable disease that is reported in high numbers or is a concern of healthcare professionals. Who's going to pay for that? Fourth, the only criteria listed here is the volunteer be over 65 and a homeowner. There are other considerations, such as the means of transportation. If the volunteer drives, what about the parking? Are there going to be smart cards, parking, or fuel stipends? If so, who will pay for that? Fifth, will there be a limit on the number of volunteers allowed to a nonprofit or school? Finally, there are the administrative costs not addressed, such as those of orientation, record keeping, and providing documents for the tax purposes.
Thank you. Go right ahead.
Good evening. My name is Kathy Gugulis, and I'm here to testify in opposition to Bill MC 2320. As a senior citizen, a property taxpayer, and a volunteer, you might think I would favor a property tax incentive for seniors who volunteer. But those are the same reasons I oppose this bill. First, because of cost. The bill doesn't address how much lost revenue this will cost the county. Given that the county is facing declining tax revenues and increasing costs, this bill seems short-sighted. How will the revenue shortfall be made up? By imposing higher taxes on the working population? High taxes already are driving people and businesses out of the county. And the number of new ways our elected officials are devising to spend our taxpayer money is just going to make the problem worse. Second, people who give back to the community by volunteering usually do so without expecting payment. Seniors who need additional income usually pursue money-making ventures, like getting a part-time job or using their creative talents to make money, or starting a business. This bill would make the county a de facto employer of volunteers. Will the county then pay for health and other benefits as they do for regular employees? Third, what nonprofit organizations will qualify a volunteer to be eligible for these property tax incentives? Will all nonprofit organizations qualify, or just a selective few? If all nonprofit organizations, again, there's likely to be a huge cost. If a select few, then court challenges from those left out will result in a huge administrative cost. The purpose of the bill is unclear. Is it to help schools get additional resources by paying so-called volunteers? Who's going to hire, train, and perform security checks for the volunteers? What are the tax implications of accepting direct value for service performed? There are just too many unanswered questions with this bill. Passing the bill is like signing a blank check. You wouldn't do that on your private account, and you shouldn't do it on the taxpayer's account. Thank you.
Thank you, Ms. Googleus. Any questions from the committee? Wonderful. Well, thank you very much. That concludes the hearing on MC 2320. And now we are moving on to the last bill for the Economic Development Committee of the night, MC 1220, the Montgomery County Stable Homes Act. Delegate Wilkins is going to present this. Do you want me to call the panel up with you, Delegate? Okay, so we have three panels on this bill, two in support and one in opposition. The first panel is Matt Losak, Zafar Shah, Kristen Sargent, Chris Perry, Victoria Price, and Mayor Kate Stewart. So you can all come up, and I'll remind my colleagues here that we heard this bill last year as well, and we did vote it out of delegation. So we can try not to be redundant with our questions, but obviously it's important to give it a full hearing. With that, Delegate Wilkins.
Thank you so much, Chairwoman. Hi, everyone, again. I am Delegate Janelle Wilkins, for the record, presenting MC 1220. This legislation, as you all know, the Maryland Stable Homes Act, Just Cause, is really about affirming the right to housing for residents in Montgomery County and making sure that everyone in our community is able to live in a safe and stable home. So to cut to the chase, as we have a number of people who will be testifying, I want to make sure I really highlight the fact that we're really unable to achieve stable housing if our neighbors in our rental homes, if they can be displaced for no reason at all, which is currently the case. If you pay rent and you follow the rules, a renter should be able to stay in their home and not risk severe destabilizing displacement and potential homelessness. Currently, with just 60 days notice, a landlord can displace a resident at the end of a lease with absolutely no ability for a resident to keep their home and without a reason being provided by their landlord. And that is the issue that this legislation seeks to address. As I've shared before, there are at least 15 jurisdictions across the country who have a similar type of legislation. And we really want to affirm this right in Montgomery County. I thank you all for the overwhelming support of the delegation for this bill in the 2019 session. And so I'll keep my remarks short and just ask you to please vote favorably again for this bill. The only other thing I do want to flag is that the County Council did vote in unanimous support in favor of this legislation this morning. They do have two amendments. One of them you do have in front of you, which basically brings the bill back to how we passed it in the delegation in 2019. We do need to work on, however, working with the County Council around the will of this delegation, which deals with getting some additional data and just the best way to do that. So that was something that the county council raised today that we still have to work on. So with that, I will conclude.
Am I on? Is it red light means go? Red means go? Good evening, county delegates, and thank you for having us. My name is Matt Losak. I'm executive director and a co-founder of the Montgomery County Renters Alliance. We're an alliance of more than 30 nonprofit, civic, religious, political, and tenants associations. And we were established as the first organized voice for renters in this region, focusing on renter outreach, education, and organizing tenants associations. I want to thank this delegation for its overwhelming support of this legislation last year. I will also keep my remarks brief, except to say that the county's demographics continue to change. We are seeing more than 400,000 county residents now living in rental housing. It is not just an interest of renters to be stable in their housing. It is an overwhelming county interest in stable, affordable, quality housing. It matters for children in public schools. It matters for our seniors in terms of their health and stability. It matters in terms of citizens' investment in their own social, economic, and political culture in their communities. People need to be able to plant roots. People need to understand that they can stay in their homes as long as they like, provided they abide by basic rules which we all agree to. This bill does not prevent anybody from being evicted who deserves to be evicted. There's never been a problem with evicting truly problem tenants. The Landlords Association will tell you they can't get rid of MS-13 or child molesters or people making meth labs in their living room. We as the Renters Alliance don't want them in our communities either, and neither do our renters. Landlords have the ability to evict these tenants today. What they also have the ability to do is silence people seeking their promised or required services and their rights without having to say, or state in any way why they are doing so. This has a silencing effect on our communities. We saw it at Flower Branch, where numerous tenants came to us and said, we had complained about smell of gas, we had complained about the quality of life in this community, and we were told if we kept talking, we might be evicted. We cannot have a silencing effect, a chilling effect on these communities. They must feel safe. We do not oppose the landlord's right to evict a tenant who deserves to be evicted, but we do believe that people, absent a good reason, should be able to stay in their homes. And we do believe that a good landlord would have no problem with this legislation. Only a landlord who is unscrupulous, who wants to get rid of tenants seeking their rights, would ever oppose this legislation. Thank you.
Okay. Good evening. My name is Zephyr Shah. I'm an attorney at the Public Justice Center, which is a nonprofit kind of legal firm, if you will. We provide free confidential legal services to tenants throughout the state to the tune of about $700 to $750 per year. I'm a practicing attorney, and I practice in district court eviction cases almost daily. This bill, the Stable Homes Act, protects tenants that I work with, families that I work with, from arbitrary lease termination. And I want to give you two examples from what I've seen of how this bill would protect people in real terms. So the October before last, I took on a client. I'll call her Andrea. Andrea was 62. She lived in a multifamily building for seniors. She lived there for over a year in a walkable, trendy area. She really liked it. All was well until there was an incident at her apartment. The maintenance staff had entered the unit while she was disrobed, and outraged, Andrea gave the property manager a real piece of her mind. But in response, the property manager put her housing at stake, telling her that he would not be renewing her lease. In his words, Andrea no longer, quote, fit in at the building, and then he followed up with a written notice stating, as I said when we spoke, I'm not renewing your lease. Under current laws in Maryland and Montgomery County, this notice suffices as the legal grounds for a tenant holding over action under Real Property 8-402. And at trial, there's nothing to prove in this case except that the notice was timely provided. And without a just cause eviction protection, Andrea would have no recourse. Statewide protection against retaliatory eviction would not have applied to her situation. But there was a silver lining for her. because her building was a HUD subsidized building. And under a HUD model lease, good cause is required for lease termination. So that applied in her situation. That was the silver lining for her. Today, I encountered Denisha and her grandfather, Charles. They live in a sprawling townhome community by the water. Denisha appeared in district court and intended holding over action. Her grandfather, the actual lessee, could not make it today because for the past few weeks he's been staying in an inpatient rehab hospital. The judge in this case was concerned when she heard that. Were the tenants paying rent, she asked the landlord. Yes. Was the landlord notified that the grandfather was in a rehab facility? Yes. Hadn't Denisha informed the leasing office of their intent to stay? Yes. And the judge literally asked this question, does this really need to happen? And the agent for the company explained that they had sent a letter, they had not received a renewal signature form, and they were proceeding because that's how they do things. And the judge, perplexed, asked, are you really going to evict good tenants? And there was no real answer. And so we have two contrasting situations here. One where a family was protected by good cause in the lease, and one where that person, a market tenant, didn't have that protection. And that's the kind of protection that this bill provides.
Thank you.
We urge your support.
Good evening. I'm Kristen Sargent, an attorney with the Montgomery County Office of Maryland Legal Aid. Thank you for the opportunity this evening to testify in support of the Montgomery County Stable Homes Act. Maryland Legal Aid provides free civil legal services to low-income and senior citizens across the state of Maryland, primarily in the areas of public benefits, family law, housing, and consumer law. I, along with my colleagues, regularly represent low-income and senior citizen residents here in Montgomery County who have been served with notices to vacate their homes or with an eviction action by their landlords. It is based on this experience that I believe the protections afforded to renters by this bill would significantly improve the lives of residents of our county. I'd like to provide a few brief examples. I represented a mother with 2 elementary-aged children who rented their home. After their written lease expired, they became month-to-month tenants. The landlord gave the family a standard no-fault notice to vacate in August of last year. Legally sufficient, standard stuff. No grounds for me to challenge this notice on the mother's behalf. It's just business, just contracts, right? The problem is the disproportionate adverse impact this had on this family. The notice was served just days before school would have started. The older child had some special needs, and his neighborhood elementary school had worked really hard the previous year to meet those needs, and both mom and child really liked the school. The mother didn't want her son to have to leave the school at all, let alone start the school year there and then have to change schools a few weeks into the term. She told me she was willing to leave, but only if she could do it 9 months later so that her child could finish the school year at this school. Ultimately, we negotiated a settlement that allowed the family to stay in the home until the winter school break. I also represented a senior citizen in a similar situation, a month-to-month tenant with a no-fault notice to vacate. Again, the landlord's business decision carried potentially catastrophic outcomes for this senior citizen. The client's doctor explained that the senior was experiencing memory loss and cognitive impairment, somewhere in between normal age-related memory loss and dementia. The senior knew how to get to the doctor's office, the grocery store, the bank, the post office, because she had driven those routes frequently for the previous decade. The doctor explained that a change in her environment brought on by having to move would likely hasten her cognitive decline and limit her independence in these activities of daily living, essentially speeding up the aging process. We were unable to help that client remain in her home and never got an answer from the landlord as to why they moved to terminate her. Had it already been law, the Montgomery County Stable Homes Act would have avoided both of these outcomes. Its passage now would allow renters in these situations these 2 clients found themselves in to have remained in their homes. Thank you again for this opportunity to testify.
Who would like to go next?
Go next. All right. Thank you. Thank you, Madam Chair. I'm Kate Stewart, the Mayor of the City of Tacoma Park, and I'm here to support the bill on the behalf of the City of Tacoma Park. As we have noted in previous testimony before Montgomery County Delegation, we strongly support this legislation. Delegate Wilkins' bill promotes stable housing by requiring a landlord to state a justifiable reason before evicting and displacing residents in the county. This bill would help correct the existing process, which is unbalanced and unfair, by prohibiting a landlord from displacing a tenant from a leased property without a just cause. This bill provides protections for renters against potential unfair treatment, discrimination, or surprises that could have far-reaching impacts not only on individuals and families, but on whole communities. Matthew Desmond, in his book, Evicted, Poverty and Profit in the American City, wrote, "It's hard to argue that housing is not a fundamental human need. Decent, affordable housing should be a basic right for everybody in this country. The reason is simple. Without stable shelter, everything else falls apart. Involuntary displacement leads to job loss and economic instability, increased student mobility, loss and damage to personal property, homelessness, mental and physical health issues. The city staff in Tacoma Park and myself personally have witnessed firsthand the devastation of involuntary displacement on residents. It's a lifetime of belongings quickly packed up or left on the street, ruined by rain and snow. Older residents or young families quickly scrambling to find a place to stay. Children moved from one school to another. All of this negatively impacts not just these individuals and families, but our whole community. The City of Tacoma Park has a number of assistance programs and staff ready to help and work with landlords to help people stay in their homes. But we need this legislation to help prevent involuntary displacement. And I want to give you just one quick example. As I was on my way here, I got a call from our city manager who said that we've been working with tenants in one building to help organize a tenant association, and the organizer just got an eviction notice today that we're investigating. And this is, as other panelists have talked about tonight, what happens all too frequently. And we want to be perfectly clear that this bill does clearly outline the process and justifiable reasons for evictions, and still permits landlords to continue to be able to evict a tenant who breaches their lease, engages in criminal activity, endangers other tenants, or does not pay their rent. As public servants, we all want to ensure that if anyone is being removed from their home, it is for good reason. The City of Tacoma Park has a wide range of rental housing types, from large apartment complexes to small multifamily buildings with only a few units. We currently do not have the protections from involuntary displacement, but would like to join jurisdictions across the nation that do. For these reasons, the City of Tacoma Park supports and urges a favorable vote on this bill. Thank you.
The red one? Sorry about that.
If your light is red and you're not speaking.
No, it was already on. I didn't realize it, and it shouldn't have been. Okay. To the Honorable Montgomery County Delegation, my name is Victoria Price. I am a resident of the Charter House, a senior citizen building, and I'm a 13-year board member of the Charter House Residents Council. My current position is community liaison. My personal experiences in this senior citizen building are directly related to my favoring Bill MC 12-20, the Montgomery County Stable Homes Act. During my 14-year residency at the Charter House, I have witnessed multiple occasions in which management companies have removed residents for no offenses related to their leases. The situation that I relate to you now, for the record, is not applicable to current staff, but nonetheless is applicable to this bill. Two neighbors came to me because they had complained to management that their apartments were not in move-in ready condition, and that management had retaliated by falsely accusing them of threatening and verbally abusing staff. One resident had complained that her kitchen sink backed up several times a day, several days a week, rendering it unusable. I visited her apartment and photographed what appeared to be a backup from the laundry room directly to her apartment. Because of the odor, she became afraid to stay in her apartment and began to spend most of her time reading in the lobby. When she fell asleep during the evening hours, upper management ordered the security guard to call the police. Our residence council pro bono attorney informed us that our neighbor could not be arrested for falling asleep where she lived and paid rent. When her lease term ended, her lease was not renewed, thus rendering her homeless. When I researched my own files related to this apartment, I discovered that the same complaints from other seniors about this unit spanned 6 years. Given that this bill is supported by major citizens organizations and our county executive, I am deeply disappointed and distressed that under Councilmember Kumar's leadership that it has been blocked. Barvey, I'm sorry, has been blocked. I apologize, has been blocked and should not be for what is our right to stay in our homes. I urge you to pass MC 12-20 and give residents an equal justice footing with their landlords. Thank you.
Good evening, representatives of the Montgomery County Delegation. My name is James Christopher Perry, and today I speak in support of the Montgomery County Stable Homes Act, MC 12-20. I'm a retired Air Force Vietnam veteran. For nearly 3 decades, my civilian job was consulting cybersecurity for the United States government. I'm currently president of the Tenants Association in my apartment community. My wife and I both retired on a fixed income, and for 10 years we've lived in an apartment in downtown Silver Spring. Every year, we get an invitation from our landlord to extend our lease for another year or two. If we don't receive the invitation, we must leave our apartment at the end of the lease term. It's that simple. No invitation, lease expires, and we're out on the streets. The landlord need give us no reason. He or she simply chooses not to invite us to extend. Let's be honest about why we need a Housing Stability Act. It's about protection from retaliation for speaking out. It's about protecting tenants who insist a landlord remove mold, plug a leaky faucet, or provide other services guaranteed by law or lease. It means losing your home without just cause when you stand up for your rights. Although there are anti-retaliation laws in the books, it's nearly impossible to prove a landlord has retaliated against a tenant. I know there are some of you who rent to tenants, and I'm sure all of you make sure your tenants live in safe, comfortable dwellings. But there are landlords who, unlike you, are lazy, who skimp on building materials, hire unqualified repairmen, and generally regard tenants' concerns as annoyances, rather than as residents pursuing their rights to promised or required services. To rid ourselves of complaining tenants, these landlords simply uninvite the tenant to extend the lease and problem solved. But what they have done is frighten the whole renter community into silence, thereby denying them a basic human right, freedom to enjoy a safe, secure, stable home.
Thank you very much. Do we have questions for this panel from the Delegate Cullison?
Thank you, Madam Chair. Mr. Shaw, so I am not well versed in this area of the law, but what I heard you say, and I want to clarify this, that in the situation where the house, the apartment was subsidized by HUD, there is the requirement for provided information around the cause. Is that correct?
That's correct. So not every subsidized property, because there's different types of subsidies, would have that guarantee, but this particular building did have that, and it was not only guaranteed in the lease, but it would also be according to federal regulations.
So that was under federal regulations, not related to a specific building. And if there was another apartment that was a HUD apartment in another building, wouldn't that also apply?
Depending on the type of subsidy.
Okay.
So if it were a project-based voucher versus a low-income housing tax credit, that the insurance of good cause termination would be different.
So would it be, what percentage, and if you have no idea, tell me you have no idea, but what percentage of rental units would be affected by that specific HUD provision?
I don't know the percentage, but I would say it's a fraction. Not
a fraction of 1%, or is it 5%? I mean,
I think we're talking about. Maybe my colleague who also practices in this area would lend some credence to this, but I would say it's in the lower thousands of units, and we're talking about tens of thousands of units.
So, but my point is that there is some experience with this.
And that's why I brought it up.
Okay.
You're exactly right. So what you see is that there's this concept at work, and it hasn't caused any kind of catastrophes or shutting downs of properties or unforeseen consequences that are detrimental to the community or to renters themselves.
Okay. Thank you very much. Thank you, Madam Chair.
Any more questions? Great. Thank you so much to this panel. I'm going to call up the next panel of supporters, which is Diane Hibino and Dylan Shelton.
I can begin? Okay. Good evening. I'm Diane Hibino, co-president of the League of Women Voters of Montgomery County. First, I want to express our appreciation for your service to the county in working to keep us moving ahead and in the right direction. Thank you all. But tonight, I'm here to add our voice and to urge you to join us in supporting the Just Cause Eviction Protection Bill 1220. The League also just signed on to a letter for the same bill, which is also titled Stable Homes Act, introduced by Delegate Janelle Wilkins. We agree that a landlord must state a justifiable reason before evicting and displacing residents in the county based on our League researched and studied positions. The Maryland State League, of which we are a part, believes that requiring landlords to provide reasons for either terminating tenancy or initiating evictions is a means of discouraging retaliation. Furthermore, our own county league and its position adds support for warrant of habitability and protection against retaliatory evictions. Without this protection, renters are in danger of losing their homes in retaliation for merely pressing for safe, habitable dwellings. A stated reason should also help protect them from discrimination due to race, religion, and other similar causes. This issue is increasingly important as Montgomery County's renter population continues to grow. I am one of them. According to the County Planning Department data, renters increased from 32.1% in 1990 to 35.3% in 2016. During this period, the county added 91,000 new households, 45% of them renters. New renters tend to be younger or older households. Older households often have fewer resources for coping with losing their homes, as we just heard. Younger ones seem to be just opting out of living in Montgomery County altogether. The percentage of heads of households under the age of 35 in the county actually declined 23% between 1990 and 2016. So, please help keep Montgomery County vibrant and able to provide safe and affordable housing for all by voting yes for Bill 1220. Thank you very much.
All right, good evening, representatives of the Montgomery County Delegation. My name is Dylan Shelton. I'm a renter in downtown Silver Spring, and I respectfully request your support for MC 1220, Montgomery County Stable Homes Act. As I said, I rent just outside of downtown Silver Spring. I'm a working millennial trying to survive in Montgomery County. And if there's one feeling I have about renting in Montgomery County, it's a feeling of being associated with uncertainty. I don't plan my life further than 2 years out. And why is that? Well, it's the longest amount of term of a lease I can get from my landlord. It's a 2-year lease. Because that's the longest time I can get, I don't really plan further than I know I'll be living in the county because of the cost of housing and because of the housing that's available to someone within my working means. And this is primarily because the Stable Homes Act isn't in place here. We don't have a just cause eviction legislation. Tenants are like homeowners. We want stable, secure housing, and we want communities that we are proud of. But we also know that rental housing isn't perfect. My complex is really old. It was built around the New Deal, and actually Eleanor Roosevelt broke ground here, which I'm very proud of. And despite all this, I deal with the problems of an older apartment complex: mold, rodents, plumbing, Last summer, my heat actually went out for about 2 weeks and had to deal with that. But despite all of this, I'm incredibly proud of where I live, and I'm proud of my neighbors. I'm friends with everyone in my building. I'm friends with my maintenance staff and my apartment management. I even worked with them to make a community garden in my apartment complex. But like I said, I don't know that I'll actually be able to live there past the end of my lease because we don't have bills like MC 1220. If my landlord doesn't renew the lease, it's on me to prove that the eviction is retaliatory. I cannot afford a lawyer, so I have to either decline to build community with my neighbors and accept substandard living, or I speak out and risk being evicted and losing my housing. I ask you all tonight, please support Bill 1220. Thank you.
Thank you very much. Questions for this panel? Wonderful. Thank you so much for your testimony. We are going to move on to the panel of opposition. That is Peter Henry, Bob Enton, Gabrielle Duval, Charles Keyes, and Aaron Bradley.
Is that working now? Very good. Thank you very much. Madam Chairman, members of the delegation, Robert Enton, I'm here testifying in opposition to this legislation on behalf of the Maryland Multi-Housing Association, which is a statewide trade association for owners of residential rental property. And we had a very lengthy hearing on this bill last year in front of the delegation and a tremendous amount of discussion about it in the delegation in Annapolis and in the Environment and Transportation Committee. I just want to start out by saying that this notion that when you sign a one-year lease to rent a property, say, that what the landlord is granting to you should be a life estate, what lawyers call a life estate in that property. And you have the ability to live there if you want under this bill for 5 years, for 10 years, for 40 years, because you signed a 30-day lease, a month-to-month lease, a one-year lease, a two-year lease, that now gives you the right to occupy this property for your entire lifetime. You're not buying a house. You're not going out and getting a mortgage, a 30-year mortgage or a 25-year mortgage that you have to pay. What you're doing is signing a lease. And what this bill does, it has nothing to do with stating the reasons why your lease was not renewed. What it says is that, in effect, you can't terminate the lease except for one of the enumerated reasons. Now, I could sit here and say, well, you know, this doesn't cover this situation. It doesn't cover that situation. It doesn't cover this situation. And I guess the bill could be amended if you thought that made sense to say, well, that should be just cause as well. And that should be just cause as well. But it doesn't go to the heart of the issue. The heart of the issue is that this is a lease. It is not a grant of a life estate in the property. And when that lease term is up, both parties can walk away. That's what the current law is in the state of Maryland. That is what the current law is in every jurisdiction in the state of Maryland. And this bill doesn't say, oh, by the way, you know, you, the tenant, if the landlord hasn't done anything wrong, you don't have the ability to leave. You must stay. So on behalf of my clients and I think the rest of the landlords in Montgomery County, we would very, very strongly urge you to give this bill an unfavorable report and not support it. Thank you very much. Right here. I know it's yours.
Hi, good evening. My name is Pete Henry. We own apartments. And I actually didn't sign up as part of this whole group. I did it independently because we really feel strongly about this. I talked a few weeks ago about the differences and the problems we have in proving the burden of carrying why we actually would ask a tenant to leave. There are two different concepts. One is a default by eviction, and the other is a non-renewal. Those are two distinctly different things. And I'm going to keep moving on this because I know you've got a lot of people. On the default by eviction, we've been operating for 7 years now. We've done about 3,100 leases. That's 33,500 monthly payments. So we've had tenants come forward and pay monthly rents, 33,000, about 500 times. On average, 6% don't pay on the first. Okay, so we send them a note and remind them. At the end of the 10-day period, there's approximately 8 that haven't paid. We then have to, now if this was a commercial lease, we would say you're into a default. We give them a notice and there's a cure date. If for us, it's called an eviction notice. And then it takes between 90 and 120 days to where if they pay the rent, they can stay in the lease, which is what we just as soon prefer. Over the 7 years, we've had 18 evictions. I'll keep moving. The reasons for the 18 evictions. 12 of them completely abandoned the unit. But if they leave a bed in there, you can't move them out. You have to go through the legal process. We had 3 identity thefts. Those are people that came in with their fathers or grandfathers or whatever, said they were leasing for them. They weren't. We had 1 death by natural causes. Our computer tracks these things as though it's an eviction, but actually it was we had 1 murder-suicide where our tenant went over and had a dispute with her boyfriend. And we had two non-payments. Out of those 33,500 leases, we had 2 non-payment evictions. With both of those people, we arranged to have their luggage or their belongings put inside a locker, which was ultimately at our cost. The evictions, we had nobody over 50 years of age. There were 28, or most were 28 to 35. None were physically handicapped or mentally handicapped. On the non-renewals, 7 years of operations, 3,100 leases, average of less than 1% non-renewal, 60, 90 days renewal notice. Reasons for non-renewal, 32 non-renewals. 14 partying noise complaints. I'm sorry, that wasn't us. Smoking cigarettes and pot. Prove it. It wasn't us. 1 physical abuse. This is where they literally brought the police out and talked to them. 1 verbal assault and abuse of other tenants. They reported it. And 1 illegal activity for the 32. So the last thing is, again, none of those were over 50. And there are 2 different points here, default and evictions. It's exactly right. We want good tenants to stay. They're important for the community.
Thank you very much.
Good evening. My name is Gabrielle Duval, and I'm the Executive Vice President and General Counsel for Southern Management Corporation. Through our 12 Montgomery County communities, we provide over 4,400 apartment homes and contribute over $8 million annually in state and local property tax revenue. Landlords, particularly owner-operators like Southern, thrive on tenants who stay and pay. Contrary to popular belief, we are not looking to evict tenants. It costs us between $10,000 and $28,000 to turn over an apartment. It costs us weeks of rent to turn over an apartment, days to weeks. It is expensive for us to lose valuable tenants. We value our tenants. We value longevity. We recently celebrated at our Summit Hills community a 50-year-old resident who's been staying with us for 50 years. That's the kind of tenant we enjoy and we want. We do not want to evict our tenants. However, the eviction process is vital to us operating safe and strong communities. Landlords do not abuse the eviction process. Out of 4,411 apartment homes, in 2017, we issued only 47 management notices in all of Montgomery County. In 2018, we issued only 15 management notices, all of which were for cause. In 2018, we filed 8 tenant holding over cases and went through with only 2 evictions of those cases. These numbers are not staggering, they are anecdotal, and there are reasons behind them. The truth is, we value and want our residents to stay, but we want our residents to stay in safe and clean communities. Eviction is not our go-to action or our first resort. Tenant holding over and breach of lease actions are time-consuming, costly, and they set bad precedent for our community and our residents. We use them only as a last resort to help keep our communities safe and clean. If we cannot remove disruptive, hostile, or drug-abusing tenants, then how can we provide safe homes for our remaining residents? When we have suspected gang activity, how will we prove that under this bill? The bill would require us to bring in witness testimony. Are we going to ask our hourly wage tenants to take a day off of work unpaid and come testify against their neighbor that they're scared of, that's not a practical reality. The proof is going to be very difficult, and it's going to make it impossible for us to evict tenants that are known disruptors to our communities. We have to be able to protect our existing residents and our families. What will you say to the resident who complains of a rodent infestation when the apartment above has been infested for months, but they won't let us in to treat? Currently, under law in Montgomery County, it takes between 4 and 8 months to evict a resident using the existing process in the county that excludes non-payment of rent. We do not need to extend that process further. Just cause is not needed in the county. What is needed is safe communities that can be policed by the landlords. Thank you.
Good evening. My name is Charles Keys III, and I'm a regional manager for Grady Management. We manage about 8,000 units in Montgomery County. I've been in property management for 24 years, and I'm confused by the need for this law. Our industry is in the business of providing housing for people. In a perfect world, we would not have evictions, but unfortunately, we don't live in a perfect world, so evictions are sometimes necessary. Each lease agreement that residents sign have policies and procedures that must be followed by both the landlord and tenant. If either deviate from those policies and procedures, there are consequences that we can sort out by both parties, or sometimes require a court appearance to provide a decision based on the evidence supplied. We recently had a resident that would hang out in the hallway of the building with 5 or 6 friends and block the stairs to the entrance of the building every day. Residents would have to ask them to move each day that they came home from work. Imagine the frustration of the residents that had to ask them to move while they tried to enter the building where they lived. Now, this does not rise to the level where police can help us because it's not a crime, but it is interfering with other residents enjoying their home. We tried to address the situation with the resident, but they didn't comply. In addition, we had 3 other residents move out of the community because of this. My point is, we don't need a list of limited causes when you have the lease agreement. We shouldn't change the law based on extreme examples that may not represent a large enough sample size of what is actually happening in the community. No business wants to lose money, and evictions certainly lead to that. So in closing, I would like the council to understand evictions are a last resort and not something that we use to punish our residents. Thank you.
Excuse me. Good evening, Chair Kelly, delegation members. I'm Erin Bradley, Vice President of Government Affairs for AYOBA. I've submitted a written statement of opposition to this bill, but I'd like to raise a few points here this evening. As you've heard today and in the past, there are concerns over this legislation's impact on community safety. However, I'd like to focus my remarks on defining the scope of the problem this legislation seeks to address. AYOBA's membership understands that most tenants, like housing providers, are responsible members of a shared community. This shared community only thrives when both sides honor and uphold the contract that governs the relationship, the lease. Eviction is an option of last and extreme resort. No housing provider wants to upset family stability, nor do they want to spend thousands of dollars associated with turning over and leasing a unit between one resident and the next. It is a poor business decision to hasten residents out, especially residents who pay their rent on time and follow the rules. Unfortunately, we know there are instances that warrant the extreme step of seeking a writ of restitution. According to the Maryland Judiciary, in FY 2018, 48,713 landlord-tenant cases were filed in Montgomery County. Of those cases, DLS reports 47,930 actions were failure to pay rent cases. That means only 783 cases, or 1.6% of cases filed, were for a reason other than a tenant failing to pay their rent. The Montgomery County Evictions Report offers data from 2010 to 2017 and also states that most landlord-tenant cases filed result from failure to pay rent. On average, between 2010 and 2017, there were 950 evictions per year. So 0.7% of county leases resulted in eviction per year during the 8-year period analyzed. I don't bring this data up to downplay the very serious ramifications of each and every resident's displacement, but to question if this county is truly faced with a rampant problem, particularly one that requires limiting evictions to only one of 7 predetermined reasons, when housing providers can clearly illustrate how this legislation will tie their hands in quickly addressing serious and dangerous violations. The evidence does not support the notion that property management is throwing residents onto the street in retaliation or otherwise. That said, AOBA agrees that no resident should be unlawfully evicted in retaliation for exercising their rights. Thankfully, staff of the Montgomery County Commission on Landlord-Tenant Affairs reports that from 2002 to 2018, there have been 2 cases before the Commission alleging retaliatory actions by landlords, with a landlord and a tenant each prevailing in 1 case. Regardless of the reported infrequency of retaliatory evictions, 1 is too many, and AOBA would be happy to work with legislators to strengthen the state's existing retaliatory eviction laws. Thank you for your consideration, and I'd be happy to provide any additional information as you deliberate.
Thank you so much. I just wanted to give Mr. Henry a chance. I know you ran out of time. Did you want to complete your last thought, or are you good?
I think they said everything needed to be said. Everybody go home.
Perfect. Does anybody have any questions? All right. Thank you very much for your testimony, and that concludes the hearing on MC 1220, and I will pass it back to Chair Corman.
Thank you, Chair Kelly, for your efficiency. Delegation will now move on to the work of the Education, Elections, and Housing Committee. Chair Queen, take it away.
Okay, so we're going to start with MC 1320. That's the bill on the Montgomery County Board of Education compensation. So I have as one of the speakers Jay Espy. Anyone else going up to? Okay. Yes. So want to make sure everyone knows that we will be holding a public hearing in Annapolis on this bill once the Board of Education's compensation report is released. Okay? So we'll schedule that. You may start.
Thank you so much. My name is Jay Espy. And on behalf of the Montgomery County Board of Education Compensation Commission, who are in attendance with me here today, as chair, I want to thank you for allowing us to present our summary of the compensations recommendations from our forthcoming report. The commission was established pursuant to chapters 121 of 2018, and while the commission has a comprehensive charge detailed in the law, the essence of our charge has a single deliverable, and that is to recommend any needed changes to the current compensation for members of the Montgomery County Board of Education. The commission held 9 public meetings throughout 2019 and determined, in order to finalize its recommendation, input and data from the various resources and stakeholders in Montgomery County and elsewhere around the country needed to be analyzed and factored into the recommendation. Commission members shared and reviewed information regarding, among other things, other school districts, other elected offices, and the work of the Montgomery County Board of Education. The recommendations have been guided primarily by the principle that the board should represent a wide range of experience and expertise found among residents of Montgomery County. You know, much is expected of board members, including the student member of the board, in terms of time and dedication of effort, ability to manage and determine appropriate action on multiple and complex issues, a willingness to communicate regularly with the superintendent of staff of Montgomery County Public Schools, with MCPS students and their families, with others in Montgomery County government, and with a wider community, and a sensitivity to the ongoing and evolving needs of current and future MCPS students. As a result, the Commission believes that the current salary level is not reflective of the time and effort needed for a board member to fulfill their duties and responsibilities, nor of the type of the work that the board is called on to perform. The Commission voted unanimously and recommends that the publicly elected members of the board receive $60,000 annually, indexed for the cost of living using the state formula, and that the president of the board receive $70,000, which is also indexed. The Commission also voted unanimously and recommends that the student member of the board receive a stipend of 20% of the publicly elected board member's salary and receive a scholarship of the greater of 80% of the publicly elected board member's salary, or 40%. This part is the clarification in your notes. Further, the Commission is confident that the recommendations would enable Montgomery County to expand its candidate pool due to the substantial time and commitment required. Board members have a wide range of responsibilities, including public hearings, working sessions, meeting with advocacy groups, board meetings, task forces, national conferences, meeting regularly with school parents and teachers, and hearings. The Commission wishes to thank the people who have been indispensable to our efforts, and we stand ready before you to answer any of your questions should you have them.
Okay, thank you for your testimony. Any questions? Okay, that concludes the hearing on
Thank you.
MC 1320. Thank you. We will now hear MC 820, Montgomery County Public Campaign Financing, Board of Education. Delegate Moon, you're speaking. Okay. And did you want me to bring up the panel, Joanne Antoine?
Yeah, that'd be lovely.
Okay. Come on up.
Good evening, colleagues. MC 820, it's one of the simpler bills I've introduced. It is enabling legislation only, and it deals with Montgomery County's public financing system. State law currently restricts Montgomery County and other counties to only be allowed to use their public financing systems for county executive and county council races. And since Montgomery undertook this experiment in democracy, there's been expansion in terms of more counties taking a look at this. So Howard County and Prince George's have now put this reform on their implementation calendar, and Baltimore City is looking at it, and I expect that over time more and more counties will look at it. But I started looking at expanding it in a different direction, and that is to allow Montgomery County to use this system for more and more races. So the bill before you, MC 820, would allow the county to use this for school board, the Board of Education. And I handed out a sheet here that shows you, our school board members are elected in staggered terms. So it shows you the pre-primary and pre-general campaign finance reports for the top two candidates in each of the school board races from the last two cycles. And what you will see is that for the most part, these candidates are raising between $1,000 and $10,000 for their races. Now, the reason why I think this is exceedingly problematic for democracy is that every single school board race in Montgomery County is a countywide race. And so we are expecting a meaningful debate and voter education to happen in a million-person jurisdiction with expenditure levels in the $1,000 and $10,000 mark. Now, I'll put some of my cards on the table. When I ran for office for the first time, I spent about $90,000, and by the second time, I was able to cut it almost in half, down to about $50,000. But that district is 1/8 of the territory that the school board candidates need to run in. So I don't care which school board candidates you like, but it seems a very reasonable thing to allow Montgomery County to expand this. If they so choose, the county would have to act, they would have to fund it, and they would have to establish the thresholds for qualifying for public financing. So that's the bill in short.
Good evening, chairs, vice chairs, members of the delegation. My name is Joanne Antoine, Executive Director of Common Cause Maryland, testifying in support of MC 820, which would allow those jurisdictions that have already established public financing programs to be able to expand and cover the Board of Education. As Delegate Moon already noted, momentum for these programs continue to grow throughout the state. Outside of Prince George's and Howard County, Baltimore City's bill right now is sitting on the mayor's desk, which we expect him to sign. Baltimore County voters will have the opportunity to pass a charter amendment in November 2020. And Anne Arundel and Frederick County have also expressed interest in creating programs. And this momentum is building because Marylanders believe, again, that special interests, wealthy individuals, LLCs, corporations have too much influence over our elections right now. Following Montgomery County's first use of the program. I believe Marilyn Perg's report highlighted that those candidates who opted into the program actually received 98% more individual contributions than those who weren't in the program. As a resident of Montgomery County myself, I got to see candidates go out of their typical way of doing outreach, right? You saw them going into communities that were largely ignored. When I look at the ethnic community, a lot of them were making contributions for the first time. We also had a lot of residents asking us how to access, the campaign finance database, right? And trying to figure out where money was coming from. So again, there's a demand for this program. And in Montgomery County, we saw more diverse candidates that don't have access to huge donor pools, right? Being able to build more campaigns that were a lot more competitive, and those options should be available to the Board of Education candidates as well. Again, at Common Cause, we believe that special interests influence our politics at all levels of government, right? Not just at the county level, but it goes from the governor to the Board of Education, and we hope that you all will support this legislation. Thank you.
Okay, thank you for your testimony. Any questions? Okay, that concludes the testimony for MC 1820. We will move now to MC 1920, Montgomery County Elections Early Voting Centers. Senator Smith, would you like me to bring up your panel or after you speak?
Sure, it's fine.
Okay, so can we have Tara Bradford, Jerry Garson, David Naiman, Elise Barnes, and Alan Banoff? Should be enough room for everyone. Okay, Senator Smith, please.
Thank you, Madam Chair, colleagues. Senator Smith on behalf of MC 1920, sponsored by Delegate Lukey and myself, to add a 12th voting center here in Montgomery County to be specifically located in the White Oak area. Under state law, it mandates that if you have a population of over 450,000 voters, that you can have a 12th voting site. And so here in Montgomery County, we have 650,000 voters. So we're well within that limit, and it's well needed within White Oak community. And I'll spend some time going through why that's the case. But I specifically want to thank Councilman Tom Hucker, an activist, Daniel Caroma, obviously the D20 delegation, the D19 delegation for pushing for this legislation, especially as I watched it from abroad. So obviously on October 31st, the Board of Elections struck down on a 3-2 vote. It was a partisan vote, that there will not be a 12th voting site here in Montgomery County, hence the need for this bill. What this bill does, pretty simple. It just mandates that Montgomery County have a 12th early voting center, and that it be in the White Oak Community Recreation Center. That's the amendment that's before you. I think there's another amendment that Councilman Tom Hucker will have before the delegation a little bit later, which I consider a friendly amendment, just basically some clarifying language that we wouldn't go to the 13th voting site. A little bit more about the White Oak community. In the county, the early voting, since we had it in 2010, early voting has actually tripled. So it's been a tremendously successful program. And that's actually happened, that's been borne out a little bit higher up in the White Oak community. It's a densely populated area. It's comprised of mostly working families, about 50% African American, 22% Latino and Hispanic. About 35% of the population don't have access to a motor vehicle. So to go up to the Praisner Center or down to the Silver Spring Civic Center actually takes 3 times longer than if you were to do it by car. So this is something that we critically need. It's something that the voting population is there to sustain this voting site, and something we think is critical to allowing everyone access to the franchise. So with that, I ask for a favorable report, and I'll turn it over to some of the other folks that are here in support of the legislation. Thank you.
Leanne, yes. State your name and
Good evening, everyone, members of the delegation. My name is Tara Bradford, and I am Policy Manager with Common Cause Maryland. And we are in support of MC 1920, a bill that would add an additional early voting site to Montgomery County. Common Cause Maryland believes that voting should be easy, accessible for all voters, no matter who they are or where they live. And we are definitely in favor of establishing an additional early voting site if that means that voters will feel like they have a real opportunity to take advantage of early voting in Montgomery County. And I want to echo the previous testimony about the White Oak area and how vital an additional early voting site would be for that community. And because of those factors and the desires of the community to have the additional early voting site, we are definitely seriously in support of this bill. And we believe this bill will increase access to our democracy, and we urge a favorable report from you all. Thank you.
Did you have a particular order, or do you want to go, Mr. Banoff? Okay, Mr. Garson can go.
I'll go next. I'm Jerry Garson, speaking in favor of MC 19-20, a bill, as Senator Smith has said, that is stated with the amendment specifying the White Oak Center for purposes of requiring Montgomery County to have a certain number of early voting centers. I was previously a member of the Montgomery County Board of Elections before we started early voting, and remember the very long lines with multiple hour waits, especially in the morning, for residents to vote at their local polling place on Election Day. We think this bill is a good start in reducing the long lines that will occur for the presidential election early voting that will occur in October. Early voting for the general election will be on Thursday, October 22nd through Thursday, October 29th from 8 a.m. till 8 p.m. In the 2016 presidential election, 162,532 voters voted early, compared with a total of 482,980, or 33.6% of the voters voted early. The waits on Election Day were short at most polling places, which occur in November. In 2020, the amount of early voting should increase and cause probably more lines. The addition of one additional polling place will reduce the lines countywide. I'd really love for us to have 15 voting sites, but that's not part of the bill. In 2020, the amount of early voting will probably increase. Historically, whenever people have gotten used to it, see that they don't have to get up at 5 o'clock in the morning and get online, they like early voting. We ask for a favorable vote on this bill. We are concerned about the State Board of Elections wanting to have the 6 largest jurisdictions to network their poll books in every precinct on the Election Day in November. This adds a major security concern, and I don't know if this could possibly be an amendment to this bill, not wanting to have greater security networks. We know many foreign countries are interested in hacking our election and if you have poll books open on Election Day, with about over 200 poll books open, and each one having like 1, 2, 3, 4, 5, or 6, this leads to many security concerns, and I hope someone would look at this in the legislature and see if we can avoid this problem. I thank you very much for your time.
Good evening. I'm David Naiman. I'm the Secretary of the Montgomery County Board of Elections. I'm speaking just for myself today. The lines that Mr. Garson referred to as being a thing of the past are not a thing of the past. On Election Day, General Election Day of 2018, we had 57 county polling places, which is about a quarter of our polling places, that had peak waiting times of more than the 30-minute national standard. And in 12 Election Day polling places, including 3 along the Route 29 corridor, the peak waiting times exceeded 1 hour, and in fact, one exceeded 2 hours. Early voting helps to shorten lines at the polling places on Election Day. That's why I enthusiastically support the legislation that Senator Smith and Delegate Lukey have introduced. We're pleased that the County Executive and the County Council are also supporting the legislation. We also strongly support the amendment to specify that the White Oak Recreation Center will be the 12th early voting site. When you passed the Potomac site in 2016, that's exactly what you did then. You specified the site. What's good enough for Potomac in 2016 is good enough for White Oak in 2020. They say a picture's worth 1,000 words, but I think a map may be worth about 10,000 words. So I'd like to show you this map of the waiting times on Election Day from 2018. This is the White Oak Community Center. This is the North Potomac Community Center. What you will notice is that the darker the precincts are, the longer the wait times, and you can see a lot of dark over here, which is the Route 29 corridor, and you can see a sea of yellow, which is the 15 minutes or less waiting time over here next to North Potomac. The need is over here at White Oak. The need is not over here at North Potomac. Even when you take into account the level of early voting utilization, you will still find that these folks are not utilizing early voting very much, and they still have short lines. These folks are utilizing early voting. Those who utilize early voting have shorter lines, but everyone over here has really long lines. This bill will help to fix that. Thank you very much.
Good evening. My name is Dr. Elise Barnes, and I am the co-chair of the Friends of White Oak and a member of the Montgomery County Board of Elections. I want to speak in favor of the bill to add a 12th early voting site, and I respectfully request that you add placing it at the White Oak Recreation Center. One of my colleagues on the Board of Elections compared White Oak to the moon. While White Oak may seem as distant and as barren as the moon to her, it is my home, and we're talking about my neighbors, Dave and Ashley, Renita and Fatmata, Grija and Pierre. So as the only member of the board that actually lives in East County, this is personal for me. As residents of White Oak, we are confronted every day with the east-west divide in Montgomery County in terms of amenities, economic and business development, convenient transportation, and county support. But where we should not experience it is in our polling places. Voting is not an amenity, at least it should not be. Having a county council member compare Election Day lines at the East County polling place to voter suppression in Kansas and Georgia, seeing national newspaper stories about 2-hour wait times and the number of provisional ballots being cast must never happen again. Having too many people trying to vote on Election Day is no different than having too many cars on the Beltway. There are only so many lanes. Additional equipment will help, but it is not enough. The voters of East County deserve full measures. Interest in the 2020 election is already high, and we can't get this wrong. Shorter wait times and fewer provisional ballots are measurable goals. 2020 is coming, and the readiness is all. The reason community support for the early voting center at White Oak is so high is because there was a problem in East County, not North Potomac. Ultimately, what my neighbors are asking for is quintessentially American, to walk to their polling place and vote in a reasonable amount of time. Given that some of my ancestors paid for the opportunity to vote with their lives, $117,000 out of a $5.8 billion budget doesn't seem too high a price to me.
Delegate Queen, Chairman Zucker, Chairman Corman, members of the delegation. I support MC 1920 because the county needs an additional early voting center to cope with the potential 100-year storm that will come next year in the primary and the general election. Over time, as Jerry Garson pointed out, early voting centers have been more popular. In the state, for example, there's an increased number of people voting in early voting from 286,000 in 2010 in the gubernatorial election to 661,000 last year. Many experts are predicting record turnouts in the 2020 elections. I've pointed those out to you in my written testimony here. Michael McDonald anticipates a 100-year storm, the greatest turnout in maybe 100 years. The Brookings Institute expects a massive turnout. Locally, Fairfax County officials expect between 85 and 90% of registered voters in that county, which is similar to ours, will vote in the 2020 election. Here as elsewhere, we can expect great numbers of voters in the primary, which could have 10 to 12 more Democratic presidential candidates on the ballot. And in the general election, where voters with very strong feelings vis-a-vis President Trump will want to vote their convictions. The Brennan Center for Justice advocates more use of early voting to mitigate against waiting times on election days. It predicts, quote, experts may disagree about the exact level of expected turnout in 2020, but some estimates suggest as many as two-thirds of all eligible voters may cast a ballot, which would be the highest presidential turnout in more than 100 years. I also urge you to earmark White Oak for the center. Transportation is a very severe issue, as my colleague Elise pointed out to you. People drive in the North Potomac. They don't drive as much they don't have the cars in the eastern part of the county. and my testimony to you outlines to you the bus disparities. More buses serve the White Oak Center as opposed to the Dasik Center. Thank you.
Okay. Thank you for your testimony.
Madam Chair, just one thing I'd like to mention is that emergency status would be needed for this bill to take effect before the April 28th primary in 2020, because the state and the local boards have to certify all the locations 6 months before. So just wanted to flag that for the delegation.
Yeah, we're aware. Thank you very much. Any questions for this panel? Yes, Delegate Love.
Thank you. A number of you have mentioned the importance of White Oak, and I really appreciate that. Thank you, Chair Barber. Bravo. Could you tell me, if we didn't put in specifically that it would be White Oak, what is the process that would occur to choose the 12th site, and why should we specifically mention White Oak?
Let me take that one. Under state law, as Senator Smith just pointed out, usually 6 months in advance, there is a vote of our board. Under the statute, our board recommends to the state board the early voting sites, and then there is a 12th early voting site without this legislation that is essentially subject to agreement between what's called the governing body of the county, which in this case is the county council and the county executive, and the state board of elections with the assistance essentially of the local board. We've been through that process. I'm sure you all are familiar with how that has gone. Essentially, we have had differences of opinion, 3-2 votes on some occasions, and on some occasions we haven't voted, but we knew that the vote would be 3-2. The state board has a supermajority requirement. So in their case, they need 4 votes in order to do anything, and you can see that this is a recipe for a deadlock. In addition, because we are so close to the election, and because if you pass this legislation in January, we'll still just be, just 3 months shy of the primary in April, there really isn't the time to go through that process again if we were able to reach agreement. So it's really important that you specify the site, as was done in 2016 for Potomac, for similar reasons, in order to make sure that we have it in place for the primary in April of 2020. Thank you.
Any other questions? Okay, thank you for your testimony. We'll bring up the opposing panel. Jim Schleck, Susan Bauer, Amy Wakehoff, Marcus Alzano, and Cheng Tu. You can take a seat anywhere, and then we'll get started. Susan, you want to start? Want to start here, or you need to start? Okay, go ahead. State your name and go ahead.
Thank you, Chair, and members of the delegation. I'm Jim Schalick, President of the Board of Elections. First, let me say thank you for the opportunity to appear. And secondly, let me say how I resent any allegations of voter suppression by the majority of our board. And I'm speaking for the majority of our board who are here and support this. You gave us legislation for 2020 that the 12th early voting site would be optional, okay? You gave us the word optional. And we took the option of saying nowhere in the county. We didn't vote against White Oak. We voted against an early voting site anywhere. You said optional. We took the option of no early voting site. So if you don't like it, why is there an emergency? Because we took the option you gave us. If you don't like it, that's not a reason for an emergency legislation. We didn't vote for an early voting site anywhere. If you wanted one, why didn't you make it mandatory? Say you're going to have a 12th early voting site. Why give us the option? And so we have to go through all this name calling and having uniformed police at our meetings. You know, I guess we're just like the rest of the country now. Anyway, the majority voted against the 12th early voting site because right before that we got a $350,000 bill, which Jerry Garson spoke about, to upgrade our communications. We tried to get Linda Lamone to change her mind. She said, no, you still got to come up with $350,000. An extra early voting site is $234,000, okay? So cost was a factor. And on the day we voted not to have a 12th site, I got 2 letters, one from Mark Elrich and one from 7 of 9 councilmen. 2 members didn't sign it because they didn't represent the White Oak area. And I'll read what Mark Elrich wrote to me, which I read before we voted. I have concerns about the cost and additional benefit of implementing another early voting site for the primary election in this fiscal year. Signed, Mark Elrich. So where's the emergency? 7, and this is all in your packet, and the letter from Linda Lamone is in your packet. 7 council members wrote us, not 9, 7, saying we support an early voting site for the general election. So your county government didn't even want one for the primary. So where's the emergency? Now, the main proponents for White Oak, which never came to us to have it as a permanent one of the 11 sites, all this rose up after the 12th early voting optional decision. But they didn't come to us with all these arguments while we were considering the 11 sites that are mandated. Why not? 2 reasons, main reasons, let me just finish, this is important. 2 main reasons why the proponents want White Oak. 1, long lines in Burtonsville. Tom Hucker helped us get $125,000 more. We're going to deal with the long lines. They're bad news. We're going to deal with it. Bus service was a critical component of their argument, that there's not enough buses, and on the weekends doesn't run enough. So, Mr. Elrich, why don't you call Mr. Elrich? Because if there was a Lady Gaga concert in the county or a football game.
Are you finished with your 2 points?
Just get Mr. Elrich to make shuttle service or more bus service available. That was their main concern. And we think this is a bad precedent to overrule the State Board of Elections, the local Board of Elections, when we made an optional decision. Just because you didn't like it doesn't make it an emergency. And we have to represent people that want early voting in Montgomery Village, Poolsville, Clarksburg. They all want it.
All right. Thank you for your testimony. Just a reminder, our mics work very well, and we can hear well as too. Okay, so please make sure you're aware of that. Next person.
Hi there. My name is Sharon Bauer, not Susan. I am a resident of Upper Montgomery County. I live in Dickerson, Maryland. I oppose Bill MC 1920, Montgomery County Elections Early Voting Centers. I am shocked that you have presented this bill as an emergency measure. I am distressed that our elected delegates have chosen to try to override the decision of our Montgomery County Board of Elections and the Maryland State Board of Elections, not once, but twice. The Montgomery County Board of Elections voted no additional voting site was necessary. There is already $125,000 set aside to add additional voting machines and personnel to the Silver Spring sites, those sites that experience delays in voters' ability to vote in a timely manner. The county already has 4 early voting sites in the Silver Spring area. There is only 1 early voting site in Germantown, Maryland, the most populous city in the county. There is no early voting site in Clarksburg, Maryland, the fastest growing city in the county. There is no early voting site in or near the Poolsville area. For Clarksburg residents, it's over 5 miles to the Germantown site. For Poolsville and surrounding towns, it is over 4 miles. These areas have very little public transportation. Your arguments that the residents of the White Oak area have to rely on public transportation do not match up with the lack of public transportation in some of the up-county areas. Your argument that the White Oak residents have to work 2 jobs or do not own cars is disingenuous. There are many up-county residents who work in agriculture with demands of 12-hour work days. I urge the delegation to withdraw this bill.
Amy.
Thank you, Chair and members of the delegation. My name is Amy Wyckoff, and I have lived in Montgomery County for over 32 years. I urge you to withdraw MC 1920, Montgomery County Elections Early Voting Centers. This bill is a solution in search of a problem. The idea that the Silver Spring area needs an additional early voting site is nothing short of ridiculous. That area already has 4 sites. In sharp contrast, the fastest growing city in the county, Clarksburg, has no early voting site. Other areas in the Upper County also have sparse coverage. Poolsville area residents must travel 4 miles to the lone Germantown Early Voting Center. And I might add that there was reference to like the east-west divide. Well, you know, there's poverty throughout the county, and Germantown, certainly in Montgomery Village, areas like that, there's plenty of poverty there and people who work 2 jobs and have a hard time getting places. Poolsville and surrounding towns have very little public transportation. Like with many other issues in the county, the needs of Upper Montgomery County residents continue to be ignored. Even more discouraging is that the delegation is using this emergency measure as an end around to the clear guidance from both the County Board of Elections and the Maryland State Board of Elections. These boards made clear that no additional voting site was necessary. I therefore strongly urge the delegation to withdraw this bill. Thank you.
Good evening. My name is Chen Tu. I actually don't have position on this particular bill, whether to increase or stay the same. But I'm in general against government waste, and believe it or not, Montgomery County has so much waste. Lots of people who pay taxes want to leave. That's my observation. I'm here to support if you decide to have the 12th site to select North Potomac Community Center as the 12th early voting site. And North Potomac Community Center was built several years ago after over 10 years delay. It has the state-of-the-art facility and ample parking spaces. Most importantly, this is the favorite community activity spot for many Asian American senior citizens. My community is right across the street from the center. I worked as an election judge in the last 2 election cycles. My wife and I had to drive to Gaithersburg Airport to vote, and it's quite some drive. And Asian American account for 15% of Montgomery County population and lack any meaningful representation in Montgomery County leadership and MCPS leadership. Selecting North Potomac Community Center as the 12th early voting site is a meaningful gesture by the delegation to improve the political participation of Asian American community. Otherwise, it's hard to counter against the notion that Montgomery County has rampant racial discrimination against Asian Americans, start from your delegation, and also Montgomery County Executive, County Council, MCPS Superintendent, and Board of Education. Thank you.
All right. We have questions. Delegate Vaughn Stewart. Delegate Stewart.
All right. Is this good? Okay. Chairman Shallett. First of all, thank you all for joining us this evening. Chairman Shallett, you said this evening, and then you've said, I think multiple times I read in the Washington Post, that you said that basically the board in its 3-2 decisions are just trying to watch the taxpayers' expenses, which is a comment you echoed this evening. But you also said in that article that I read in November in the Washington Post that if state officials are determined to add an early voting site in White Oak, they should also add one North Potomac. Yes, 2 is better than 1, you were quoted as saying. Now, to me, this seems like a little bit of a strange point. It seems to me as if I told my wife that I had checked our family's budget and we cannot afford a new car for her. And we just can't afford it. I don't care if she's taking 4 buses to get to work. We can't afford it. But if we do get her a new car, we have to construct a man cave for me in the backyard. 2 is better than 1. It seems like, to me, she would maybe, assume that maybe the fiscal constraints were not my biggest concern in that scenario, but that in fact I was indifferent about the fiscal concerns, indifferent at best about her desire to get an automobile, and really most concerned about my man cave. So I'm going to ask you what she would probably ask me, which is that how can we take serious your fiscal concerns given your 2 is better than 1 stance in the Washington Post?
Well, to me, by the way, the Washington Post didn't put half of the positions that supporters of North Potomac have. No, 0 is better than 1, and 0 is better than 2. My remarks were probably flippant, that if you all and the county council don't care about the taxpayer money, then, do whatever you want. But a lot of people want North Potomac to serve as Poolesville, Clarksburg, and that whole part of the county. So my flippant remark was that if nobody cares, we care about money. Our board cares about money. You all don't care about it. County council doesn't care about it. Do whatever you want. Have 2.
So just to be clear, you do not or you do prefer
I want 0 new voting sites.
But would
0.
you prefer us to spend $450,000 roughly, or $480,000, or $240,000?
0.
Okay.
I want to spend 0.
Okay, great. Thanks very much.
Any other questions? All right, thank you for your testimony. That concludes the hearing for MC 1920. We will now move to MC 1420, Montgomery County Authority of County Council over Inspector General of County Public Schools, Senator Kramer and Delegate Solomon. Would you like your supporters to come up, or?
Sure, that'd be great if you would be so kind. Thank you.
Okay. Jerry Garson, Paul Geller, Laura Stewart, Sheldon Fishman, and Melissa McKenna.
Good evening again, Montgomery County Delegation. Delegate Solomon and Ben Kramer here, introducing MC 1420, which would grant the Montgomery County Inspector General authority over the public school system, similar to the authority that the Inspector General has now over other Montgomery County agencies. And I will preface my comments by saying that this time last year, Chair Barvey, when a couple of other IG bills were introduced, leaned up to his microphone and he said, "Will this be the last of the Inspector General bills?" And I acknowledge that there might be just one left that would need to be addressed, and this is that one. Now, I will also share with you that the additional work that we've been doing with regard to the Inspector General issue ties directly to what we did last year when we granted the Montgomery County IG authority over the HOC as well as Montgomery College. And that currently, along with what we hopefully will do here, exists in county code. So our county council years ago gave authority to the Montgomery County Inspector General over our public schools, over the HOC, and over Montgomery College. The problem is the county council didn't have the authority to do that. So it exists in statute today. They've just never been able to act on it because it requires enabling legislation from the state. So with approval of this bill before you, we will have fulfilled the intentions of the county as passed years ago. So with that, I will turn it over to the good delegate to offer his commentary on the legislation.
Thank you, Senator Kramer. Thank you, colleagues. I will be brief. I echo my colleagues' sentiments. I think the only other point I will add is that, especially this year, as we're considering, potentially a wide, which I hope will be a widely enthusiastically supported investment in our public schools, it's really important that the public, while we're also asking them potentially to contribute more, that we are making sure that we have accountability in our system. And so I would ask a favorable report on this bill. Thank you.
I am Jerry Garson, speaking on behalf of the Montgomery County Civic Federation, Inc., and speaking in favor of a favorable report on MC 14-20. The purpose of the bill is to authorize the County Council of Montgomery County to enact a local law that grants to the Montgomery County Inspector General certain authority over the Montgomery County Board of Education and public schools located in Montgomery County. Since over half the county budget is for education, and the oversight of such a large expenditure is very important for your information, the operating budget for 2020 is proposed to be $2,680,574,773, and the capital budget for 2021 is $378,133,000. They don't seem to have the individual dollars for that one. Both are very large amounts. We would prefer that such an oversight be provided by a separate Inspector General with an adequate budget and staff to supervise the expenditure of over $3 billion. We think this bill is a good bill to the start, only if the county adds adequate staff to the Inspector General's office, because they can't really double or triple the amount of time that they have with their limited staff. When you spend over $3 billion, oversight is very important to the taxpayers of the county. We are also concerned when the Comptroller of Maryland says that it costs Montgomery County twice what it costs Fairfax County to build a school. Therefore, we get half as many new schools built, and we have a significant amount of overcrowding. If we're really interested, we should have the Inspector General check why are our costs so high. Do we have various things, which I think the Comptroller referred to, specifications that are out of date in our budgeting procedures? We have to really look, how do we get the most new schools for the same amount of money? To me, $378 million is a lot of money. I'd be much happier if we got twice as many schools built, and maybe if we have an Inspector General, this could occur. Thank you for your time.
Good evening. I'm Paul Geller. First of all, I'd like to thank all of you for being here tonight. I believe this is at least your third meeting that you've come out to, and it's very appreciated how each and every one of you, when you're so busy, comes out here and you listen to all of us about issues that are so important. And one thing that may be overlooked is I'd like to thank your staff. You are wonderful. I get here early because I'm afraid I'll miss that 6 o'clock deadline. I get here early, and I have to tell you, not only are they gracious to everyone who comes here before 6 o'clock, they're gracious to everyone who comes after 6 o'clock. And that's very appreciated, so thank you.
Can we get him more time? Is that all right?
That's okay. I strongly support this bill. As the immediate past president of the Montgomery County Council of PTAs, I had an opportunity to do a lot of advocacy work, and people would sometimes come to me and they'd mention things that were of issue to them. One of the things was outside contractors from outside of Montgomery County, even inside of Montgomery County who aren't part of the system, have a very difficult, if not impossible, time getting contracts for school construction. This is not right. School construction, as Jerry said, is over $300 million a year, and we have a tremendous backlog. One of the challenges that Melissa McKenna and I would often hear on our tours was people wanted their projects done, and they wanted them done yesterday. And if you take a look at some of these old CIP books, these projects, some of them have been languishing for a decade, 2 decades. We need to move things along. I find the best way to do this is through this very good bill. We need to have some Office of the Inspector General oversight, because we need to open up the bidding. And this is just one aspect of things that could be improved in MCPS. This is very important, though. I mean, we have to get these projects going, and this would be a great way to get it started. Thank you very much.
Good evening. My name is Laura Stewart. I am currently the Vice President of Advocacy for MCCPTA, and I'm here speaking for our organization. I'd like to thank Senator Kramer and Delegate Solomon for proposing this bill. MCCPTA supports Bill MC 1420 to give the Montgomery County Inspector General jurisdiction over the Montgomery County Public Schools. In fact, it was voted in as an advocacy priority from our membership. The 6-year capital budget presented is $1.818 billion, and the operating budget for 2020 was $2.66 billion. This is a huge, complicated budget, and many do not fully understand the complexity that goes into it. As you well know, Montgomery County has a recent history of fraud. In fact, I was on the MCCPTA board and headed up the audit committee, which helped uncover theft and fraud in our own organization. Having more oversight can discourage would-be bad actors. In our own organization, we added layers of oversight in order to gain confidence from our members. I think we could do that for MCPS as well. Confidence in our school system is so important today, especially in considering some of the issues coming up, like the boundary analysis. Given IG jurisdiction over MCPS will help taxpayers trust that their money is being used as intended to educate our kids. This will also assure taxpayers there will be additional oversight to make sure that any funds going to the Blueprint for Maryland's Future and the Build to Learn Act will be spent properly. We are not here because we think funds are being improperly spent today, but we think it is imprudent to have that extra layer of oversight in order to protect our investment and the children of this county. So with that, we support this bill strongly and hope that you move forward to have an IG look over MCPS. Thank you.
Good evening. My name is Sheldon Fishman. Thank you to you, Senator Kramer, the sponsors, and Delegate Solomon, a former teacher and a District 18 delegate. Yes. I've lived in Silver Spring for over 40 years. My family has been well served by Maryland and Montgomery County. Our 4 children were well educated by MCPS. My wife or I were on the board of the local PTA of each of our children every year they were in MCPS. To summarize, one year we were selected as the Maryland State PTA Family of the Year. Direct evidence. I represented the local PTA and the county PTA in testifying to the Board of Education, the County Council, and the Maryland General Assembly in support of increased funding for MCPS. Simultaneously supporting increased funding, I've been a longtime advocate of transparency and accountability to improve outcomes, to improve government and efficiency, and even more important today, to improve trust in elected officials, excuse me, and government. And for all those reasons, I support MC 1420. And in light of the hour, I will just say ditto to what Laura said. You know the benefits of this bill.
Good evening. My name is Melissa McKenna. I appreciate this opportunity to share my strong support of Bill MC 1420 to enable the County Council to grant the Inspector General authority over MCPS and the Board of Education. Thank you, Senator Kramer and Delegate Solomon, for this final piece of transparency legislation. We all work very hard in Annapolis to get the funds needed for MCPS in all public schools in Maryland. The Capital Grants Program for school systems experiencing significant enrollment growth that we worked to establish in 2015 and expand in 2016 has been a game changer. What started out as less than a drop in the bucket at $5.9 million in 2016 has grown to $25.9 million in each of the past 2 years. That's 44% of the state's MCPS CIP funding. That amount now exceeds the amount collected in the county recordation tax and is 4 times the amount collected in school impact taxes. Now that we've gotten the money, where does it go? We need to examine what's really going into the cost of MCPS projects and how they're built. We don't need architectural masterpieces or grand edifices for our schools. We need safe, healthy, functional, up-to-date, technologically modern buildings that are appropriate for the students who will inhabit those rooms. I call the new Seneca Valley High School the Tesla Model X project. At more than 500,000 square feet and over $175 million, can we really afford this? Could we do with a nice, sturdy Subaru, perhaps a pre-owned Honda? We need to stretch funding as far as it can go. While architecturally striking two-story entrance vestibules or media centers is that the best use of money? Even Baltimore City is building 2 new net zero energy schools for roughly the same price as conventional construction. We need this to have proper oversight. Even though it's a complex budget, it shouldn't be hard to get a simple answer, and that's what we will be able to get with this. Thank you.
All right, thank you for your testimony. Any questions? All right, I guess that concludes MC 1420. Thank you. Okay, we'll now have MC 120, Montgomery County Housing Opportunity Commission selection of chair, Delegate Shetty, and we'll bring up her panel, Jennifer Lokisa, Katie Nolan, Chris Rigaud, Marsha Coleman Adebayo, Sagoon Adebayo, Amy Millar, and Karen Lundgren. You fill up as many seats as we can.
Madam Chair, if it's okay with you, I'll go ahead and get started in the
Yes,
interest
please.
of time. Okay, thank you so much, colleagues, for allowing me the opportunity to present my local bill, MC 120, that would change the manner in which the chair of the HOC is selected. As you know, the mission of the HOC is so critical to Montgomery County. They serve so many of our constituents countywide by providing safe and affordable housing for our low and moderate income residents. The purpose of my bill is to add one additional layer of transparency and accountability that is really critical to this institution. It builds on the important work that we did last session with Senator Kramer's bill that added an IG. Under current law, the commissioners for HOC are appointed by the county executive and confirmed by the county council. My bill does not change anything in this process, but what my bill does do is it adds one additional rule that enables the county executive to select the chair of the commission. Prince George's County recently enacted a similar rule, and this enables the commission to have just one additional layer of political accountability to the community, which is so incredibly important given the critical mission they have in serving all of our constituents. In the interest of disclosure, I fully believe in the importance of collaborating with my opposition. I did call HOC in advance to get their thoughts and their opinions. About a week and a half ago, I did not get a response to see even if we could hear what their thoughts and feedback were. They also apparently called a public meeting on November 14th. They voted down their approval of this bill as well as others being considered tonight. And even though they've begun streaming their meetings on YouTube, this particular public meeting is conspicuously absent. So to me, this signals, again, the important need for political accountability and transparency. Their mission is just too critical for us to ignore that. I look forward to your feedback and questions and urge a favorable report, and I will turn the floor over to anyone else on the supporting panel. Thank you.
All right, my name is Katie Nolan, and I will be reading testimony on behalf of Surge Montgomery County. In the interest of time, I'm talking not only about 120, but 220 and 520, since all of the issues are very related. We support these bills and urge you to vote for them without any weakening amendments. As a result of the ongoing struggle to memorialize the Moses African Cemetery in Bethesda, which is currently operated as a parking lot for a property owned by HOC, we have learned about the disturbing mismanagement of this agency. The current HOC board is an ineffective commission which merely rubber stamps anything put before them by the executive director. For example, at one meeting when they were voting to approve structure of payment vouchers for the following year, HOC commissioners questioned why the voucher amounts were fixed rather than increasing to match yearly increases in rents. The executive director brushed this off as just how things were. The commissioners then unanimously voted to approve this, despite the clear detriment to the low-income people dependent on these housing vouchers. Bill 120 would bring HOC in line with best practices in other Maryland counties. It is important that the chair of HOC's Board of Commissioners be accountable to the public they serve, not merely HOC's executive staff. We could further improve by making all members of the board elected positions or appointments with the involvement and approval of the HOC Residents Association. Moving on to the other ones, we support all the requirements proposed in Bill 220. None of the proposed requirements that you will read about are radical ideas. They are the best practices of many local, state, and federal government offices. We wholeheartedly reject the weakening amendments proposed by HOC. We cannot trust them to be transparent. They have failed to transmit their proposed annual budget to the County Council, despite being required to do so. They have on multiple occasions demanded fees of over $2,000 to hand over information requested through the Maryland Public Information Act. They have not responded to someone making legislation about them. They need oversight. The lack of oversight over HOC's procurement process is truly appalling. They spent $20.5 million of our taxpayer dollars to knowingly purchase the bodies of 500 Africans and continue the desecration of a sacred burial site with disgustingly little oversight by the county government. While Bill 520 may not have prevented that deplorable decision, it would bring HOC's procurement rules in line with other county agencies. When you're spending hundreds of thousands of taxpayer dollars, as has been a theme of this evening, your decisions ought to be vetted and approved. These bills are not enough to rectify the serious mismanagement issues at HOC, but they are a welcome start to making this agency more accountable to the public it serves. We thank Delegates Carr, Shetty, and Crutchfield for introducing bills to make HOC more transparent, accountable, and responsive, and urge you to support them.
Good evening. I am also only going to speak once in support of MC 120.
Would you say your name, please?
Sorry. My name is Christopher Rigaud. I am the president and chair of the Anne-Marie Derriter Indigenous Peoples Foundation. I am here to testify in support of MC 120, 220, and 520. I support MC 120, which would empower the county executive to select the commissioner of the HOC with an annual budget in excess of $230 million. The citizens of Montgomery County need diligent oversight of the HOC. The appointment of the commissioners to the HOC is already an opaque process with little citizen input. The complete disregard of Macedonia Baptist Church requests for fair treatment regarding Moses Cemetery has been shocking and appalling. With the county executive in charge of appointing and removing the chair of the commission, citizens can expect more accountability. I also support, with an amendment, MC 220, the streaming of HOC meetings and proper, timely documentation of meetings, budgets, and seminal information. HOC is the largest real estate holder in Montgomery County. As such, the citizens need as much transparency as possible. The fact that HOC chooses to hold its meetings on 4 p.m. on Wednesday is inconvenient for working people to attend them in person. Having attended almost every HOC meeting in the last 12 months, I can inform you that HOC is currently operating is not transparent to the public about its work. If we would have had streaming last year, you would have seen Dr. Coleman Adebayo right over there get arrested during a public comment period at an HOC meeting. This is why we need streaming and open transparency. I further insist that citizens be allowed to comment upon and correct inaccurate information published on HOC's website. There currently is a lot of misrepresentation about Moses Cemetery and the interactions of HOC with members of Macedonia Baptist Church and the Bethesda African Cemetery Coalition. On the website right now, there is a letter signed by Stacy Spann that states, on September 30th, 2018, HOC attempted to start this coordination by attempting to invite Regency Centers to our meeting with members of the descendant community in Macedonia Baptist Church. This effort was rebuffed by the church. This is false. It was false when it was written 15 months ago. It's false today. If you don't believe me, ask the Reverend Adebayo, who's sitting right here. I also support MC 520. As mentioned earlier, HOC is the largest owner of real estate in Montgomery County. Therefore, it is critical that proper fiduciary oversight be done. Last year, we became aware of millions of dollars being siphoned off from Montgomery County by an unethical employee, as Laura Stewart mentioned earlier. This incident should serve as a reminder to all of us that government and quasi-government entities must adhere to strict, transparent accounting practices. Thank you very much.
Okay, just a reminder, our mics work fine. Thank you.
Good evening, delegates. I'm Reverend Shegun Adebayo. I'm the pastor of. Okay. Thank you, sir.
They don't speak that well.
I'm Reverend Shegun Adebayo. I'm the pastor of the Macedonia Baptist Church. We'll be celebrating 100 years of existence ministry in Montgomery County next year. I want to thank Delegates Carr, Shetty, and Crutchfield for introducing the 3 bills aimed at shining light on the very opaque operation management of the HOC. I speak in support of bills MC 120, 220, and 520, and urge you to vote for them without any amendments to weaken them. Following 3 years of struggle to persuade the HOC to cease the desecration of the graves of our ancestors, the Moses African Cemetery in Bethesda, we have become acquainted with the arrogance and power drunkenness and disrespect and disregard, from this agency. The old saying is still very true. Power corrupts, and absolute power corrupts absolutely. In the absence of legal structures demanding transparency and accountability in line with what obtains in other agencies, this commission and management will continue to operate with impunity and disregard for our community. We and our community, we have vowed to continue to fight against the moral leadership at HOC until decency and justice prevail. The current HOC board, upon close examination, has proved to be totally ineffective, leaving a situation where the executive director runs the agency as a dictator. How do you explain the purchase of a property, sitting on a historic burial ground by HOC, following months of public protests against the former owner of the property? It can only be explained either by callous insensitivity or disregard for black people, even in death of both. Bill MC 120 will give the county executive the power to appoint the chair of the HOC board of commissioners, rather than the current system of the chair being selected by the board. While we do not consider the proposed bill an ideal scenario, this bill will bring HOC in line with best practices in other Maryland counties, and hopefully make the chair more accountable to the public and less likely to act as a pawn of HOC executive staff. As suggested by our partners, such the more democratic scenario will be election of the chair and the commissioners with the active participation of the residents of HOC properties. We enthusiastically support proposed Bill 220 to make HOC commission meetings available. From my experience, effort to obtain information from HOC under the MPA was frustrated and thwarted with a demand of $2,000 from our church. Bill 520, will bring some consistency and accountability to the procurement process. It's understanding that the HOC executive director can make purchase of almost $250,000, without going through any process. This leaves room for corruption.
Can we wrap up, please?
Nepotism. Thank you.
Okay.
My name is Dr. Marcia Coleman Adebayo. I'm the president of the Bethesda African Cemetery Coalition. Our organization is passionately committed to bestowing dignity to the thousands of Africans whose broken bodies were thrown into a mass grave, perhaps one of the largest mass graves in U.S. history, called Moses African Cemetery on River Road in Bethesda. The mass grave is owned by the Housing Opportunities Commission. This is a mass grave that contains the remains of 2 communities of African peoples. The first were Africans kidnapped from West and Central Africa, starting in the 15th century. These people were not American citizens and died citizens of their various kingdoms and nation states. In 1807, plantations turned from planting tobacco to sexual violence sites where Africans, predominantly children, were used as victims of pedophiles, breeding, and prostitution. The majority of the girls died in childbirth. Their bodies, their lives were stolen, and no one has been held to account. Their bodies lie in Moses African Cemetery. The second community buried in Moses were the descendants of the first community. They pooled their money together and they bought the plot of land that is now called Moses African Cemetery. In fact, Charlotte Gray was the first owner of Moses African Cemetery. She used her precious resources and bought the land where we believe her mother is buried. She was funeralized at Macedonia Baptist Church, and from there she was carried over to Moses African Cemetery. While France memorialized non-French citizens who fell on French soil during World War II in Normandy, in one of the most beautiful memorials in the world, Montgomery County has continued its desecration under an HOC parking lot. So what does this history have to do with MC 120, 220, and 550, which I am here to support? History has taught us that individuals or institutions that are prepared to commit atrocities in one area are likely to bypass the opportunity to make moral decisions in another. The HOC has known for years that their property sits on the graves of Africans who were kidnapped, raped, sexually tortured, and murdered. This is what European historians have liked to call slavery. We'd like to suggest as friendly amendments that the HOC must provide in writing justification for calling in the police and having citizens arrested who are simply exercising their First Amendment rights.
Want to wrap up, please?
Okay, and we are also concerned that allowing the HOC Executive Director, Stacy Spann, a discretionary fund, or what I call a slush fund, of over $250,000 per project of unaccountable money encourages ongoing HOC corruption. Clearly, new leadership is needed at HOC to curtail an agency that is clearly out of control. BACC is proud that our struggle continues to trigger legislation against HOC corruption. Thank you.
Good evening, everyone. My name is Karen Lundrigan, and this is emotional testimony. And I am in support of these three bills, as I, a voucher recipient under HOC, have been the victim of many big illegalities and retaliation by HOC, to include being illegally terminated and without any investigation done. I was forced to submit totally unnecessary medical documentation to secure a reasonable accommodation. They massively violated my privacy by advertising these ultra-sensitive medical records unencrypted all over the internet. And without any further investigation done, numerous other high-level employees were sharing this personal information with outside third parties. Furthermore, the person behind me had me to submit these unnecessary medical records, Ethan Cohen, who worked in the Program Compliance Division at HOC, was not even properly qualified to be doing this type of work. My issue is not so much with the HOC commissioners. I want to let it be known. I also had a face-to-face meeting with Stacy Spann as to this, and it was a complete disaster, as Stacy Spann in this meeting from the get-go was yelling at me, and further, I had a lot of documentation to show him that would have completely exonerated me in this matter. He yelled, "I'm not going through all of that." Mr. Spann also publicly humiliated me at a recent HOC board meeting in front of the commissioners, and I have many witnesses who approached me after this meeting. This is so unprofessional, especially coming from Mr. Spann as the executive director. Many high levels of HOC lack one critical ingredient, and it is called respect and human decency, which they have not shown me or so many other people. HOC has also claimed governmental immunity in an attempt to get away with their numerous illegal actions, yet a judge recently ruled that HOC, in fact, does not have governmental immunity. You know, I'm literally sickened by what HOC has gotten away with under the direct leadership of Stacy Spann. Please, please pass these bills, as there desperately needs to be some serious accountability and oversight and regular monitoring, and by an outside credible party, Delegation. I can only say it is about time. This is one big step towards holding HOC 100% accountable. I thank you for allowing me all to have a voice in this matter. Happy holidays, everybody. Thank you.
Good evening. My name is Amy Millar, and I'm testifying here this evening on behalf of UFCW Local 1994 McGeo. We had the opportunity to testify in front of members of the Montgomery County delegation back in September, And in that hearing, we asked delegation to work with us to improve oversight, transparency, and accountability, and to protect the delivery of public services at the Housing Opportunities Commission. The four HOC bills that you have before you today all address these priorities, and I want to thank Delegates Carr, Shetty, and Crutchfield, and Senator Kramer for introducing them. The need for affordable housing and supportive services in this county is at an all-time high. And it's more important than ever that this agency is accountable to the public. MC 120, Housing Opportunities Commission selection of chair, it mirrors, as has been presented this evening, it mirrors law in Prince George's County, where the county executive selects the chair of its housing authority from amongst the commissioners. Appointment of the chair by an elected county executive who answers to the people rather than appointed commissioners provides for greater public accountability, and that accountability is very much needed. As we heard others on this panel testify, there has not been that level of responsiveness from members of the commission. I can say that when our union has brought issues to the commission or have seen residents or members of the public bring issues, unlike in other commissions or boards that we have experience with, there have been no questions, no engagements, no engagement on the issues, and no follow-up. It's very much perfunctory. Go ahead and I'll listen to what you have to say, and we'll do absolutely nothing with that information. The commission oversees a combined operating and capital budget of over $430 million, and it serves thousands of Montgomery County residents. This is prudent legislation to ensure the accountability to the public the commission serves. So on behalf of our members, which include over 200 HOC employees, we ask for a favorable report on this legislation.
For the record, my name is Kevin Berenz. I'm here to ask you to support the three local bills to improve oversight, transparency, and accountability for the Housing Opportunities Commission. I have been involved in the struggle for the memorialization of the historic Moses Cemetery, currently desecrated beneath a parking lot at HOC. I have experienced HOC's reticence towards disowning its role as a grave desecrator. I've often marveled at the fact that I can find no other instance of anyone or any organization this side of the Ku Klux Klan that declares its pride in the desecration of an African cemetery. Yet this is what HOC has done consistently when we have challenged its ongoing desecration. Thus, since HOC has consistently demonstrated that it has no moral compass, it is imperative that oversight, transparency, and accountability be imposed upon HOC from the outside. In addition to the stipulations set forth in the three local bills, I strongly urge you to add the involvement and approval of the HOC Residents Association to the process of creating oversight to rein in HOC's rogue and sociopathic behavior. I urge you to support these bills and to enhance and to enfranchise the HOC Residents Association in the process. Thank you for your consideration.
All right, thank you for your testimony. Any questions for this panel? Okay, thank you very much. We will bring up the opposing panel. Stacy Spann. Okay. Okay, let's start.
Good evening, members of the county delegation. My name is Stacy Spann, Executive Director of the Housing Opportunities Commission of Montgomery County. The panel took all the bills at once.
So what we can do is you can talk to this one. I have one more person who was a supporter for 2020. I'll bring them up for that one.
Do you want me to do that one first?
No, do this one first.
The 120?
Yeah,
Okay,
do 120
excellent.
first.
Okay. So again, thank you for the opportunity to submit testimony and to explain why the delegation should oppose the bill. MC 120 would transfer the authority to select the chair of the HOC board, long held collectively by the commissioners, to the county executive. HOC is an independent, quasi-governmental agency responsible for creating and preserving affordable housing in Montgomery County. Under current law, the county executive nominates and the county council confirms each member of the Board of Commissioners. Commissioners are unpaid volunteers chosen for their professional backgrounds and ability to contribute to the Commission's affordable housing mission. The commissioners, selected and confirmed through a system of checks and balance by county government, then elect their board leaders every single year. The tradition of rotating commissioners in leadership positions, such as the chair, ensure that diverse views are always part of the leadership of the agency's policymaking body. In truth, as you all know, we are facing an affordable housing crisis right here in Montgomery County. And while we are fortunate to have many allies in the work we do to keep people housed and get them housed, we still face as many opponents who remain vocal about keeping affordable housing out of their backyard. Often the communities HOC creates and supports are not initially revered or appreciated by neighbors. These attitudes usually dissipate over time, but remain a hurdle to increasing affordable housing in the county nonetheless. MC 120 in its current form would enable a single entity to politicize the leadership of HOC's policymaking body, while the chair and other leadership positions are, much like the county council president and vice president, still just one vote among many. These leadership bills also have an informal platform to share their viewpoints. It's critical that those viewpoints remain diverse and independent to ensure the agency stays true to its mission and the needs of HOC customers amid dissenting community voices. Current state law explicitly delegates the responsibility to choose the chair to the Housing Authority after the agency's inception. Absent any prevailing issues that warrant changes to that selection process, the authority should remain with the Housing Authority. For these reasons, we ask that you oppose MC 120. Thank you.
Are the other folks here testifying or just here for information?
I would like to speak. I am
go ahead.
chair of the Housing Opportunities Commission this year, and I thank you.
Would you state your name, please?
I'm sorry, Jackie Simon, and I thank all of you for your time and your patience. I'm a 60-year resident of Montgomery County. I've spent my entire career advocating for affordable housing, and as an HOC commissioner, as well as an HOC employee back in the late 60s and most of the 70s, donating 20 hours a week of volunteer work with civil rights and nonprofit organizations in our county. As an HOC commissioner, I've had the privilege to serve with many dedicated, mission-driven professionals who've devoted the benefit of their personal and professional experience to HOC's board and mandate. My fellow commissioners hail from different racial, cultural, and professional backgrounds. The diversity of viewpoints on the commission and the commissioner's ability to carefully consider and vote for a chair whose vision will help steer the work of the commission to ensure HOC stays true to its mandated mission, which is to increase and preserve affordable housing throughout Montgomery County. The current practice of annual elections amongst the commissioners ensures that a diversity of viewpoints receive access to leadership positions on a well-balanced and diverse board. The chair serves as one of 7 and has 1 of 7 votes. Not only does this ensure broad geographic representation and assures a chair is selected who has the time to be available at the time they are elected and suited and committed to lead the work program for the coming year, but it also supports the race, equity, and inclusion efforts this county values. The fact is that affordable housing needs in Montgomery County are too great to subject the work of the commission to political control without any checks and balances. The checks and balances are the appointment and confirmation of the commissioners. When more than 30,000 households remain on HOC's waiting list for housing services and resources, we simply cannot bear the risk that our affordable housing goals could fall to NIMBY influences. For these reasons, I strongly urge the delegation to oppose Bill MC 120. Thank you.
All right, questions from Delegate Corman.
Thank you, Madam Chair. Mr. Spann, I don't normally ask questions at these hearings. I just think it's not the best idea for the seat I'm sitting in. But three things have happened during the course of the past 15 minutes that really, I think, raise a lot of questions in my mind about your interaction with this body that I just want to give you a chance to respond to. Number one, the sponsor of the bill raised concerns that she reached out and did not hear from you. So I'd like you to address that. Number two, I really appreciate that HOC has started streaming. I think that happened after we had that briefing over the summer that you and a number of members of your team participated in, which we appreciate. I'm glad you're streaming. It's been stated that one of your meetings was not streamed since that time, so I'd like to give you a chance to respond to that. And number three, I guess this is just more of a reminder. The 40 witnesses who came up before this for the various bills all signed up, and there's a process to sign up, and so I'd encourage you, when you're bringing up other witnesses to support your testimony, to make sure they go through our sign-up process, because we operate by rules and procedures. So let me give you a chance to respond to those, and then we can get on to my colleagues' questions.
Okay. I appreciate the opportunity to respond, and we'll take address each issue in kind. The last issue, the last one I'll start with first, the sign up. We absolutely believed that we had signed up. I will take full responsibility for that mishap. We thought we had signed up. We had actually alerted the commissioners to that effect. So that was at least one commissioner got confirmation. I'm not sure what happened there, but again, that's my responsibility. I apologize to the body for that. With regard to Delegate Shetty, I don't know who you left a message with. It was with me. Well, you know what? That is an oversight on my part. And you said it was a week and a half ago? Okay. As I don't have an excuse except that I missed that call. And you know, here's the thing. I accept responsibility when I mess up. Mm-hmm. I am human. I'm not offering that as an excuse. There is anyone in the body who has worked with me prior to this. I am normally exceptionally responsive to calls and email, and so in the event that in this case I clearly missed it, and I certainly apologize. There was no attempt to avoid collaboration on the bill. We're welcoming, and I think you're talking specifically about 120, correct? And so I would have told you at that point the rationale for opposition. I can't offer an excuse except that I missed the call. Okay. Streaming was the next one. And it was September 26th that we said that we would get streaming up and running. We promised December to have all the kinks worked out. We actually at that point in September hadn't had all the equipment, and so we have been working through streaming. And in fact, we streamed successfully one meeting. The second meeting, the equipment went down. And so we have been working to sort of make sure that we've worked out all the kinks. It was a new effort on our part. We had not streamed anything. We guaranteed December. We're still right now at the throes of December. Our next meeting is tomorrow. Wednesday. That will be streamed. We had an equipment malfunction. That's really it. There's nothing else.
Thank you, Madam Chair. I guess my question is, are the duties of the chair versus the other commissioners, vice chair, are those spelled out in bylaws somewhere? Does the commission have bylaws? And I didn't see them on your website. If you have bylaws, would you consider posting those on your website so that they would just be transparent?
Certainly. So the two questions. We would absolutely will post the bylaws. There are bylaws. The duties are slightly different in that the chair sets the agenda. That said, on every agenda conversation, a different commissioner, so it rotates, a different commissioner participates on that call.
And are you aware that what this bill seeks is already the law in Prince George's County?
I am aware that the Prince George's County Executive chooses the chair of the commission there. There's a pretty significant difference between Montgomery County and Prince George's County in the way that the housing authority works. And in fact, there, the housing authority is a direct part of county government. It is not here.
All right, and just in closing, going off on a tangent, so in our district, District 18, there is a relatively new building called the Lindley, 200-unit apartment building in Chevy Chase Lake. There was a shooting there a couple weeks ago, but I guess my question is, could you get back to me and tell me what is the occupancy rate of that building? How many of those 200 units are occupied and how many of those units are vacant?
I can certainly get back to you and tell you the precise numbers. Just so you all know, there was in fact a shooting. Montgomery County Police responded. The individual involved in the shooting, essentially it was an attempted robbery. So that individual has now moved from the property, and police are having custody of at least one participant in the robbery. With regard to the occupancy, it is currently in lease up. So and what that means is generally from the period that the building opens, working through the kinks, through stabilization, which is when we get a normalized occupancy. It's still in that process right now, but I can certainly give you the precise numbers.
Thank you, Madam Chair. Jackie, thank you for being here this evening. Having been born and raised in Montgomery County, I know that your service to this community has been very long-standing and very much appreciated, and it is with great respect that I thank you for that. Also, having been born and raised in Montgomery County, I have always been aware that the HOC was held in very high regard and that the issues that have been, I think, I would say, sort of plaguing the commission seem to have begun to manifest themselves in very recent years. Would you share with me the process for the contract with your executive director? How often is that contract renewed? And when was the current executive director first hired?
That was prior to my being appointed to the commission, but I will tell you that that contract is reviewed annually, and the executive director is evaluated annually, and I don't remember what year of, I believe it's a 5-year contract that he's currently in, but.
So it is a 5-year contract, and when you say it's reviewed annually, it doesn't terminate on an annual basis and then is renewed. It is a 5-year commitment. Is that correct?
The current contract is a 5-year commitment. I don't know prior to that.
And so would you know then whether the current executive director had served prior? Or, well, let me ask you this. How far into the current 5-year contract is the current executive director?
I'm not certain. I'm not.
All right, then I will ask the executive director, Mr. Spann, how far are you into the current contract?
Honestly, I think it's a 3-year contract, and I believe I am in the second year of that contract.
Second year of that contract.
But
And how many terms in that did you serve, or how long have you been in that position with the HOC?
Since February of 2012.
Okay. So we were approximately into, I guess, so if it was a 3-year contract, you went through the first 3-year period, and now maybe, I guess at this point, you're within the second or third contract?
I am within the third, I believe. I mean, Senator, the commissioners have the ability to let me go. I'm an employee at will. They can let me go at any point.
And has that ever been, Jackie, has there ever been conversation about letting the current executive director go in light of the concerns that have been raised over the past several years with regard to the operations of the HOC? Has that conversation taken place?
I don't think that is an appropriate question of me in this setting. And
well, I was just asking as chair of the commission, in light of legislation that would propose giving others the authority to make the appointment, I thought it might be appropriate to try to glean or get some insights as to the commission's response to concerns that have been raised, and I think particularly with regard to the commission's selection of the executive director. So, I'm just asking if if you deem it inappropriate, then so be it.
certainly at this time in my tenure as chair, that has not been discussed, and I think I can speak for my colleagues that he enjoys the confidence, the accomplishments of the agency, and the number of units and number of people we've been able to house under his leadership has been phenomenal, and the agency has been recognized nationally over and over again for the creative financial capacity and the development and the ways that the agency under his leadership has led us to be able to use other resources rather than just government subsidies. And we are able to budget and plan for maintenance of our inventory, which other housing authorities cannot do because of the constant reduction of operating subsidies from
Can you
across the
share
country.
with me if there has been discussion about the executive director and the attention that has been brought to the commission in recent years, and perhaps some of the controversial and unfavorable concerns that have been raised about the HOC? Have those discussions taken place, or can you share that, or are you not comfortable sharing with the delegation that information?
I believe that Mr. Spann leads the agency as a competent executive director. We as commissioners are policymakers. There has not been conflict.
Okay,
During
thank
my
you. No,
leadership.
you've answered the question. Thank you, and I do appreciate that. Thank you very kindly. Thank you, Madam Chair.
Sure. Delegate Acevera.
Thank you, Madam Chair. Just a few questions to Chair Simon. HOC is a creation of state law, is it not?
It is.
HOC has the responsibility of serving Montgomery County residents and in providing affordable housing. Is that not the mission?
It does, both as a housing authority and a housing finance agency.
And HOC is the recipient of county public dollars as well, is it not?
Yes.
So given all those three things, would you then agree that reasonable and proper oversight of and judicious oversight of the HOC, a quasi-public agency, but a public agency nonetheless, that there should be reasonable and proper oversight of that agency. Would you agree with that?
I think proper oversight, maybe we are looking at a range of levels of oversight.
Right.
I think that the appointment process provides oversight in the county's interest, and particularly
we could get
related to county money.
We could get into the intricacies of that oversight, but my question was, given what I just mentioned, you would agree that there needs to be reasonable and proper oversight of the HOC as it relates to taxpayers' dollars?
Assuming that you understand that we have the resources coming from federal government,
Right.
federal law,
And they will have their own standards.
and they
right?
have their own standards
Correct.
with which we have to comply. We
Right.
comply with the standards of the resources of the money that
But
come
you would
to us.
agree that there needs to be reasonable and proper oversight as there is, in any other county agency.
Audits, all of these other things, public
Okay.
disclosures.
So
absolutely.
part of that oversight is the board, right? And because each of you all are appointed and not elected, someone that makes that decision in terms of appointing those individuals and approval of the council. Is that not the process?
It's important to understand that when the public housing laws were created in 1936, there was a specific intent that it be an independent agency
Right.
where there could not be plebiscite or political pressures brought. And I would suggest to you, each one of you, that there are decisions that come to us and pressures that come to us that you're happy or should be happy not to endure.
Right. So I'm talking about the process here, and I hear what you're saying, and I appreciate that. I'm talking about the process. So there is a commission, and each of you all are appointed and approved by the council, are you not?
Yes.
All right. So you mentioned in your testimony earlier that in order to avoid the commission becoming, in essence, political control, that the chair should not be appointed by the county executive. Are not all of the members appointed by the county executive, whether it's the current or previous?
And that's where the
But
oversight.
are they not? Is yes or no?
They are, and
Okay,
that's
so
where
then you would
oversight
agree-
comes in.
You would agree to
We
coming
don't
back to
batter
your
our we
statement
don't
earlier.
batter our witnesses. I mean our.
I'm not battering. I'm just following up questions.
All right, so change the tone, please.
My tone is the same.
Change the
My
tone,
tone is the
please.
same. My tone is the same, Madam
Don't
Chair.
interrupt her. Change the tone.
My tone is the same, Madam Chair. With that being said, you had mentioned earlier about political control. So then would you agree that the commission is already under political control given the structure?
Yes,
Thank
I would
you.
agree. That additional, the appointment of the chair should be left to the organization who is aware of the work agenda that we're facing, and the commissioner that is best and has the most time to devote to the work plan for the coming year.
Thank you, Madam Chair. I'm really confused because I want to bring this back to MC 120. So all of the commissioners are nominated by the county executive.
All the commissioners are nominated by the county executive and then confirmed by the county council.
So currently, the commissioners who are all nominated by the county executive choose amongst themselves who to be chair.
That's correct.
And this bill would allow the county executive to nominate the chair amongst the same people he just appointed.
Well, that's not the way, as I read the bill, he could appoint or change the chair at any time, the way the bill is proposed,
But only amongst the people that he himself has already nominated.
unless there was a vacancy and he was in the process of nominating.
I'm trying to help here.
Well, I'm trying to
Thank you very much.
respond to.
Thank you, Madam Chair. How long are your terms?
Our terms, we serve for 5 years.
Okay.
And can serve a second 5-year term.
Okay, terrific. And let me just verify this. With the exception of Prince George's County, my understanding is there is no other HOC in the state of Maryland where a charter county executive appoints the chair. Is that correct?
I would defer to the executive director on that. I don't believe so.
We're actually canvassing every single one.
Okay.
But Howard County used to have something very similar because, it was part of county government. It's since spun off for the reasons around.
Well, I meant for
independence.
HOCs that are independent agencies.
Oh, no. Yes, you're correct.
Okay.
Yes.
And this is a little off the bill, but I do want to ask this question. How much auditing are you subjected to, and to whom are these audit reports reported?
All of our operations are audited, and they are reported on our website.
Are they available to the county council and the county executive?
Yes, absolutely.
Have you ever been queried by the county executive or the county council on deficiencies?
Never.
Never?
Not queried about deficiencies. And so we have the agency audit itself. There's a single audit. There are dozens, and I think it's in the 40 range of special purpose entities related to tax credits or development work, and every single one of them has an individual audit. Those are submitted to whomever the funding entity is and reported on the website. No, we've never had any queries about the substance or any activities within the audit.
Thank you, Madam Chair.
All right. Any more questions? Okay, that concludes the testimony for MC 120. So how we handle MC 220, Delegate Carr will come up. We only have one other person that was signed up that we haven't heard from. That is Louis Whalen. So he can come up. And this was all support, so I didn't have any opposed to that. So hopefully that'll be quick. And those will be the only people who probably need to speak. You want to testify on that? I think that'll be great. Delegate Carr.
All right. Thank you, Madam Chair. Good evening, colleagues. Thanks for hearing MC 2-20. This is a transparency bill, and it has 4 parts. One part is to require streaming of public meetings of the HOC's commission. I'm very pleased that they recently began streaming after some inquiries from the delegation. And so this will codify that practice and also ensure that written minutes will continue to be provided. Second part, it will require that vendor payments, $25,000 or more, will be made available to the public via a web page containing a searchable database. This will put the HOC on par with federal, state, county agencies, as well as WSSC and all Maryland school boards. Third, it provides that annual audits that are already required by law shall be made available to the public by posting them to a page on the HOC's website. And finally, it provides that HOC's draft budget, which is required under current law to be sent to the county council by May 1st of each year, to be copied to the delegation. Thank you.
Mr. Whalen.
Okay. Good evening, Madam Chair and members of the delegation. I'm Louis Whalen, live in Olney, Maryland, and occasionally I just delve into things that are in the news and so forth. So I had seen the HOC in the news a lot several years ago and again more recently. And so over the past several years, I requested copies of their internal audit reports because I like to read those. And after considerable back and forth and getting the Attorney General's MPIA ombudsman involved, I was finally given some reports. And I apologize. I think I didn't turn them in my copies, or the copies I made for you in time, but probably doesn't really matter, because here's what the reports look. Here's what I was finally given. Here's another one. You can read it from there just as well as you can read it up close. Okay, I'll just show you a few more pages here. Okay, here's this is what I was given. So I don't really have much more to add, other than I guess I'd say if I were a suspicious person, I would say that the HOC has something to hide. Okay, thank you.
All right, any questions for this panel? Okay, that concludes the testimony for MC 2020.
Madam Chair, may
Yes.
I please respond?
Oh, sorry.
I'm sorry. So, Mr. Willen notes that is an internal audit. It is not the same as the audit from the audit firm, right? And so the reason it's redacted, and Mr. Willen well knows this, he spoke with our general counsel. She indicated that there were names and other information that needed to be protected, that those are not actually subject to FOIA, at least without being redacted. And she told him exactly what he would get. He realized it and said he wanted it anyway. It's, with all due respect, this is not the same as the audit that is posted on our website. It is conducted on our operations. When we have an issue, we have internal controls, and in an effort to make sure that the agency is running well, the commissioners and myself are sometimes made aware of fraud issues, et cetera. If those are dealing with customers, those work papers are not subject to FOIA, at least the information therein. And so while I understand how it looks, it is for dramatic effect. Our audits have been published on the website. This isn't something new. We've been doing that for years. In addition to that, we've published all of the special purpose audits on the website. Every single one of them. We don't have anything to hide.
All right, thank you very much. All right, that concludes the testimony for MC 2220. We'll do MC 520. And we've heard from, go ahead, Delegate Carr.
Thank you, Madam Chair. I guess I'm up here with the opponents of this bill as well. Thank you all, Madam Chair, colleagues, for considering MC 5-20. So as has been discussed earlier in the evening, public housing agencies like the HOC, they're creatures of the state. They're local in nature, but they're not part of local government. When I inquired with the Department of Legislative Services, in our nonpartisan professional analysts in Annapolis, to inquire whether housing agencies in Maryland are required to follow any procurement rules whatsoever, either state or local. The answer came back is that when federal money is involved, there are some HUD procurement rules that they have to follow, but otherwise they are not required to follow state or county procurement laws. MC 5-20 strengthens HOC's procurement policy by codifying that it must be consistent with the county's procurement policy. It only applies to those procurements that are not already covered by federal regulations. There's precedent in Montgomery County. Non-county entities, including the state's attorney's office and the sheriff's office, are required to comply with the county's procurement rules. In Fairfax County, HOC's peer public housing agency follows their county's procurement regulations by adopting its procurement resolution each year. In Prince George's County, Maryland, their public housing agency follows their county's procurement rules. And if you just think about how some of the different agencies in our county operate, Montgomery County Public Schools, with an enormous budget, any expenditure over $25,000 comes to a vote at a public meeting by the board. A lot of municipalities operate the same way. When you reach a certain dollar limit, there is a public vote by that body. Even in Montgomery County government, any expenditure over $100,000 goes through a very rigorous process. For the HOC, the limits seem to be much higher, set at $250,000 for there to be oversight or for it to come to a vote for the commission. So I believe this bill is a best practice, will bring HOC in line with peer housing agencies, other county agencies, and as an important way that we can ensure that this very important mission, this housing money, is spent wisely and efficiently towards housing by providing that extra level of oversight and transparency. Thank you.
Any questions for Delegate Carr? Delegate Barber.
I'm curious, Delegate, are you motivated by a knowledge of some sort of procurement irregularity? Is there a problem that's been brought up in an audit report?
Yeah, I guess in doing my due diligence and learning more about housing in general and housing agencies, I've come to the belief that this is a best practice. Not to say that HOC has done something wrong, but to express our belief of the importance of following best practices, and that this would strengthen procurement at HOC and encourage the wise and efficient spending of their resources.
So the answer is no?
My answer is my answer.
Okay. Thank you, Madam Chair.
Any other questions? Okay, so just for clarity, MC 220 didn't have anybody opposing, so you're sitting up with opposing on 520. All right, you okay, comfortable there? All right. Then Stacy Spann and John Poxis.
Okay. Good evening, Chair Zucker, Corman, Chair Queen, and members of the Montgomery County Delegation. My name, again, for the record, is Stacy Spann. I'm the Executive Director of the Housing Opportunities Commission, Montgomery County. Thank you for the opportunity to offer testimony on MC 520. We vigorously oppose 520. Generally accepted financial oversight calls for agencies and organizations to follow the law and regulations governing the procurement process of the entity providing the funds. HOC receives the majority of its funds from the U.S. Department of Housing and Urban Development, where federal funds are used, federal procurement guidelines and requirements are followed. The same would hold true if HOC received any discretionary funding from the state or county. While HOC receives a small portion of non-discretionary funds from the county, which are allocated to specific programs, it receives no funding from the state. 520 would require HOC to create a parallel procurement system to Montgomery counties and require the agency to follow similar requirements for any funds not received from the federal government. To be clear, a significant amount of HOC's discretionary funding come from its own revenue-generating activities, not in the form of grants from government entities. HOC has an already well-established procurement policy in place to govern the procurement of any discretionary funds not received from the federal government, and that system complies with all federal, state, and local laws regarding procurement using non-governmental funds. The creation of a new procurement system that mirrors the county's processes and policies is unnecessarily burdensome. We're in the business of housing, folks. It's not arbitrary, it's not capricious, and in fact, the best practice for independent housing agencies is the independent procurement policy for non-discretionary funds. And I would offer that procurement policy is reviewed. It has to comply with, again, federal, state, and local law, and it is about housing. The $250,000 limit mentioned earlier is not arbitrary. It's actually subject to review. I can't simply write a check. I don't have access to our check, our checkbook. I can authorize certain things. Typically, those are emergencies that are around housing. And so the county's procurement guidelines, while it works for the county, there is almost no way to define a housing emergency in every single instance. Our effort is to serve customers. We get it wrong sometimes. You've heard that tonight. You've heard it throughout your careers. We are imperfect, but we work hard at this. We give this county every single bit of effort. And again, the mistakes are all mine. I own them. I am not running away from them. I apologize for whatever disrespect has been shown to you all, but I assure you that we take this business seriously. And we are within best practices. Thank you.
Paul.
Good evening. My name is John Poxis. I'm the President and CEO of Habitat for Humanity Metro Maryland, a nonprofit affordable housing homeownership provider in Montgomery since 1982. I would like to thank the Montgomery County Delegation for the opportunity to speak. I am here today to voice my Habitat for Humanity's opposition to MC 5-20. Habitat for Humanity Metro Maryland has worked in Montgomery County for 37 years, providing opportunities for low-income families to purchase home in otherwise unaffordable market, providing critical health and safety repairs to families struggling to maintain their homes. Each day we meet residents struggling to find safe and affordable housing in our county. In many cases, we refer residents to HOC if we can't help. Over the years, HOC is an essential provider and financer of affordable housing in our county, in addition to a great partner of ours. In my opinion, the strength of HOC is their ingenuity, adaptability, and flexibility to meet the growing and changing needs of vulnerable populations in our county. HOC is subject to and complies with federal procurement policies in cases where federal dollars are used, but should not be subjected to local procurement policies for its remaining funds as an independent agency. Like Habitat and other organizations, they have the established internal procurement policy that ensures good usage of their funds while also allowing them to best meet the needs of their clients. In the case of some governmental funding sources, Habitat had to comply with governmental procedure policies. We understand why these policies are in place for spending of taxpayer dollars, but in many cases this does add significant burden to our staff, delay in services to clients, and cause us to choose subcontractors that may not be the best fit for our clients, but are least expensive. We are incredibly grateful for government funding when what we receive. It allows us to serve significantly more families. The strength of our organization and others like HOC, though in our inability to utilize government funds where appropriate, and other dollars as supplement to, or in specific cases to allow us to efficiently best meet the needs of vulnerable clients. HOC is an essential producer of affordable housing in our community, and we believe it's in our community's best interest for them to remain a non-political, independent agency that creates their own procurement policy and most effectively and efficiently meets the needs of the residents. Thank you for your time and consideration.
Okay, Barbara.
Thank you, Madam Chair. Mr. Spann, let me put to you the question that I put to the sponsor. Are you aware of any reports of procurement irregularities in your agency?
No, sir, I'm not. And I will also add that although there was the law that gave additional OIG oversight, we had already been working with the OIG. And so we didn't oppose that bill because there is nothing to hide. There are no irregularities. And again, being subject to as many single audits as we are for all the special purpose entities, the entity itself, as well as the reporting that we have to do for HUD on every single program, not only would I be aware, but all at this point, all the commissioners would be aware, the OIG would be aware, the federal government will be aware, the state would be aware, because we do work with the Department of Housing and Community Development. They offer the tax credits that we use, as well as every single syndicator.
Thank you, Madam Chair. That's it.
Delegate Carr.
Yeah, my question is for Paul, the gentleman for Habitat for Humanity Metro. Can you tell me, does your organization also operate in Prince George's County?
We do.
Okay. And are you aware that what this bill seeks is already the law in Prince George's County?
I am aware of it, but as Stacy said earlier, it's a totally different organization in Prince George's County. They do not have a robust affordable housing program in Prince George's County. They're really just getting off the ground.
Okay. And a question for Mr. Spann. Would you be willing to provide us with a summary in the most recent fiscal year of all the HOC's spending on consultants, lobbyists, land use lawyers, and those sorts of contracts?
Certainly.
Thank you.
Any other questions? Okay, that concludes the testimony on MC 520. Thank you for your time. All right, do need to move the panel this time. Thank you. We will call up MC 2120, Senator Kramer and Amy Millar.
Thank you, Madam Chair, and again, thank you, delegation. Ben Kramer here introducing MC 2120. And since I'm batting cleanup here with the last bill of the night, I'd like to point out that we have heard several bills relating to the HOC. They are all very important, but I would also ask that you please stay very focused on what the purpose of this bill is and why it's being introduced. I have never been one that has felt privatization of public jobs serves the community or the residents, and it's not in the best interest of government to do that. And this bill addresses that issue within the Housing Opportunities Commission. And I will preface my comments before I quickly go through what the bill provides and say that just during this past interim, I testified before the HOC Commission when the Commission unilaterally announced that they were going to be changing what has been policy for years, in which their public employees were given an opportunity to be provided housing within HOC communities. In exchange for that, those employees are on call constantly. And if they get a call in the middle of the night, they get up, they go over, they address the problem within the community. The room was packed with HOC residents objecting to this unilateral change coming from the commission. They were there talking about how some of these employees have been their fellow residents for 15, 16 or more years, and how wonderful it is having them there to address the problems immediately that arise within the community. There was no explanation from the HOC as to why they made this unilateral decision without any consultation of the bargaining unit involved on the employee's behalf. Now, my understanding, and maybe Ms. Millar can correct me on this if I'm wrong, I believe the Labor Relations Board overturned that decision. Would that be correct?
LRA, yes.
So I think we do have a reason to be concerned about how the public employees at the HOC are being treated now, and concern about their positions in the future. So the legislation before you just creates a process for ensuring that if the HOC chooses to privatize current or future employee positions, that there be an impact analysis required as to how that decision will affect the employees, the residents of Montgomery County, and the public in general. It then prescribes the things that will be considered in the impact analysis. After that, it provides a process for addressing disagreements between the HOC and employees. And then finally, if a settlement is not reached, It provides for binding arbitration. That is what the bill before you does. With that, I will turn it over to Ms. Millar.
Thank you, Senator Kramer. And as you've just heard, the bill clarifies, I think, some definitions in this bill in the current law, and we think very importantly, requires the Commission to analyze the impact on employees, residents, and the public. And I think that's in the interest of the folks that we all are here to serve. I can tell you, and you have my written testimony, I hope, or you will have it shortly. In the interest of it being quite late, I will not read that to you. But we've had instances of contracting out in the past, most recently of many management positions. Property managers at the various sites have been contracted to private companies like Edgewood. That's led to I think a decrease in what we've heard from residents, a decrease in services. They've got a different set of priorities as a for-profit company than the mission of the HOC. So we think that this is good legislation, and we ask for a favorable report.
Any questions? Okay, we will hear from the opposing panel. Thank you very much. Thank you for your testimony. Mrs. Spann.
Madam Chair, given my noted earlier mistake, I'd ask an indulgence around Commissioner Priest as well. And again, I apologize. We did sign up. One commissioner at least got a confirmation. I am not sure what happened. Okay. Again, for the record, my name is Stacy Spann, Executive Director of the Housing Opportunities Commission of Montgomery County. Good evening. HOC opposes MC 2120. The Services Contract Act was passed and applied to Montgomery County government in 2006. 2008, similar legislation under the Services Contract Act was applied to the Housing Opportunities Commission through state law. Between 1999 and 2019, HOC and McGeo has successfully negotiated 6 collective bargaining agreements with relatively few grievances reaching arbitration. In short, HOC fails to see the problem this legislation purports to solve. In its history, HOC has never undertaken a service contract that adversely impacted employees. In fact, the effect of MC 2120 will be to politicize what's historically been a successful collective bargaining process. The purpose of collective bargaining is to bring both sides, employer and employees, to the table in good faith to negotiate terms and conditions of employment. Attempting to legislate a set of requirements applicable to a single agency in advance of a negotiation and insert a binding interest arbitration on an issue where an appeal and review process already exists undermines the intent, spirit, and practice of good faith bargaining. Furthermore, MC 2120 improperly vests final decision-making authority on an issue with significant budgetary implications in the Labor Relations Administrator, who is neither elected nor appointed by elected officials. Ultimately, HOC's Board of Commissioners, volunteers who were nominated by the county executive, interviewed and confirmed by the county council, and committed to representing the interest of HOC's customers and mission to provide affordable housing, must maintain the ability to review and approve or reject decisions with a fiscal impact on the agency and those it serves. HOC also urges the state delegation to consider the broader ramifications of MC 2120. The changes to the Services Contract Act proposed in MC 2120 for HOC do not exist at the Montgomery County government level, nor to our knowledge with any other agency or governmental entity in the state of Maryland. Passage of the bill will likely make MC 2120 a model for changes to all agencies at both the county and state level. It's unclear whether the consequences of this approach have been properly reviewed and analyzed at the county and state levels. For these reasons, we urge the delegation to oppose MC 2120.
Okay, state your name, please, and go ahead.
Good evening, Chairman and members of the Montgomery County Delegation. My name is Roy Priest, and I'm a 37-year long resident of Montgomery County, an HOC commissioner, and a local and national affordable housing leader for the past 54 years. I formerly served as CEO of the Alexander Redevelopment and Housing Authority and as Director of Economic Development for the U.S. Department of Housing and Urban Development. I appreciate the opportunity to provide testimony to oppose MC 2120 and to address its potential impact. Today, our region faces an affordable housing crisis. Recently, the Metropolitan Washington Council of Governments concluded the region would need 75,000 more units than originally forecast by 2030. Rising to the challenge, former Council President Nancy Navarro spearheaded a resolution calling on Montgomery County to provide 10,000 of those units. It gives me great pride to know my representatives take the real housing needs of the county citizens of my community seriously. But in order to reach that goal, we need our policies and processes to remain focused on the families we aim to serve with our housing efforts. As someone who has led a housing authority, I cannot emphasize enough how critical it is to ensure the well-being of our customers remain at the forefront of operational decisions. MC 2120 would take focus away from serving our customers, Montgomery County families who need housing and other resources to thrive. It will require the agency to weigh the needs of the families who rely on affordable housing against other factors unrelated to customer needs. Further, the process that's outlined in the bill would provide for extensive amounts of due process review that in fact would negatively impact our residents. Further, it will vest final decision-making authority on these issues in an entity which is neither elected nor appointed by elected officials to carry out HOC's mission to get and to keep families housed. I also want to indicate that during my tenure on the HOC Commission, I have never seen or approved of any service contract that impacted the workforce of HOC. For these reasons, I strongly encourage the delegation to oppose MC 2120. Thank you.
Okay, any questions for this panel?
Madam Chair.
Oh, sorry. Senator Kramer.
Thank you, Madam Chair. Mr. Spann, you offered, I guess, your sentiment that it's your belief that negotiations with the bargaining unit are always hunky-dory and everything goes just fine and they get worked out. Do I recall that just a couple of years ago where there was legislation that imposed binding arbitration with regard to some of those negotiations between the HOC and the bargaining unit?
Senator, thank you for your question. I appreciate that.
Is that correct? That legislation was passed a couple of years ago on that issue?
I'm actually attempting to answer.
Okay, thank you.
You proposed the legislation, and it was for wage arbitration only, which was formerly not a part of the law, and the reason it wasn't was because of the funding sources for the agency. So yes.
And your position on that legislation was what, Mr. Spann?
I opposed that legislation because, again, it was about the funding source. But I did not indicate, certainly did not intend to, that the process for bargaining is hunky-dory. What I said is that we've successfully negotiated the contracts with relatively few items going to arbitration.
And I'm guessing perhaps the bargaining unit might have a different perspective on that sentiment. Is that possible?
Of course it's possible.
Okay, thank you for that. To the gentleman from the commission, you indicated that somehow the residents of the HOC, your customers, would not be served well with passage of this bill. Could you explain to me, please, how having our public employees fulfilling necessary job requirements would somehow not provide the same or comparable service that privatization of those jobs would?
What I meant by that, sir, is that the service contracts that this bill would cover.
I'm sorry, could you lean? I'm just having a little difficulty, if you don't mind.
The service contracts that this bill would cover. To my knowledge, there have been no such entities contracts approved that impacted negatively the workforce at HOC. How it would affect the residents is that there's a significant amount of process laid out in this legislation. It requires a lot of staff time to provide the analysis that are required for this bill. That takes time away from the regular work that they have to do in carrying out the work that provides the services to the residents. It does not, in fact, provide a streamlined process. So there are vital services associated with service contracts that would be denied residents going through a lengthy process to assure that employees were not being negatively affected by the decisions being made for the contracts.
And I appreciate your concern about the amount of effort, but I would direct you that there are 3 itemized areas that would be reflected within the impact analysis. Is it your belief that in responding to those 3 items as to how this would impact your clients, the employees, and the residents of Maryland somehow outweighs the concerns about taking away these public employee positions and turning them over to the private sector? Do I understand that correctly?
Yes, you do.
Okay. Thank you very much. I appreciate your candid answer. Thank you, Madam Chair.
Okay, any more questions? Okay, that concludes the hearing for MC 2120.
Thank you, Chair Queen. Delegation, that concludes our pre-session work. See you in January.
If you see a butterfly with a tag on its wing, you can actually report the information on that tag back to Monarch Watch.
And we also highlight some of the cultural ties to the monarch butterfly with the Day of the Dead, and some of the Hispanic traditions from Mexico around the butterfly.